Margaret found a hole in the seat over here. Are you serious? Brand new. They spent how much money? So the units rattled. Yes, that's my proposal. Do I need to read it with you? I just mostly
All rise. Chancery Court, County's now in session. Honorable Judge David Wilson presiding. May God bless this court, the great state of Tennessee, the United States. If you got cell phones, make sure they're silent and no talk. You may be seated.
All right, good morning. We're going to start with a docket, although I think we're having some technical problems. So, all right. We ready? Let's call the first case. You want me to call it?
Case number 19855, Deborah Dabbs.
Good morning. All right, this is a motion for default.
It is, Your Honor. It's a motion for default, divorce. I thought Miss Dabbs.
Deborah Lynn Dabbs. It's-
Your Honor, this is a complaint for divorce. We filed the complaint on October 31st of 2025. The wife was served through the Secretary of State on May 4th of this year. She's not filed an answer. I have had some contact with her Your Honor, the parties have two children, they're 15 and 16. They were adopted by my client a few years ago.
Let's make sure that microphone is on there. I think you'll have to touch the bottom. Should be lit up if it's working. Okay. We'll wing it.
All right.
All of you raise your right hand that are going to be placed under oath and face the clerk.
Mr. Dabbs, you are Gary Dabbs, is that right? And you provided me with information to prepare the divorce against your wife, Deborah Dabbs, is that right? All right. And we have asserted inappropriate marital conduct and irreconcilable differences, is that correct? All right. How long have you been separated from your wife? 2 years. Okay. And during the course of your marriage, did she frequently lie to you about things that really probably didn't need to be lied about, but she lied to you frequently? All right. And did she ultimately leave and move to another state? Okay. All right. And is she living with someone right now? Is she living with a boyfriend as far as you know? Or was she at one point in time? Okay. And you and she have 2 children, is that right? You heard me say that they were 15 and 16, is that right? Okay. Now, 2 of you, you don't own any real estate, do you? No real estate. Yeah, answer on that. Okay. But you and she did buy a trailer, is that right? And is the trailer, is there any debt associated with the trailer? Well, there were some HOA fees that needed to be paid, is that right? Okay. And are you asking for today to order that trailer be sold? She's not living in it, is she?
At this time, I think she is.
Think she is? Okay. All right. But you're asking for it to be sold. Okay. Would you like for it to be put on the market within maybe 30, 45 days? And are you asking for you to be able to choose the realtor? Do you feel like if she's in charge of choosing the realtor, it'll never happen?
Correct.
All right. And then you understand that after it sells, that whatever's owing, as far as liens or HOA fees and such, that those will have to be paid. And are you asking for any remaining proceeds to be divided equally between the two? Okay. And then, sir, you have no other debts together, is that right?
I don't think so.
Are you asking the court to order that you pay your debt and she pays her debt? And the personal property has been divided, is that true? Okay. Now, you left a banjo with her. If that banjo still exists, would you ask that banjo be returned to you? And then you drive a car that's in her name, is that right? What kind of vehicle is that? Oh, no. Okay, and are you asking to be awarded that vehicle? And are you asking that she have to execute the title or that we do within the final? And in any other vehicles in her possession she would keep, is that right? And then are you asking for any other vehicles that you have in your possession that you keep? Do you have any other vehicles? Okay. Are you asking to be awarded those?
Oh, yeah.
Okay. All right. Has all the other personal property been divided? Are you asking to keep your bank account? She keeps her bank account? All right. And then, sir, as far as a parenting plan, we have proposed a parenting plan, is that correct?
Yep.
And you have proposed that the mother be the primary parent, and that you have certain visitation with the children. Essentially, And they are still they're in Ohio, is that right? Are you asking that any 3-day weekends, that you can be afforded those 3-day weekends? And then some extra time in the summer and some time during the holidays?
Yep.
And then you've agreed that because of the children's age, that they could have some discretion in regards to visiting with you. Alright, and then you understand that child support is going to have to be set. Okay, how much do you earn an hour? 26 an hour. And then are you asking for her, do you know, does she work?
I don't think she
Is she capable of working?
barely.
Why not?
I think having mental issues. And I can't tell if it's her real mental problems or she's really not wanting to work. It's not a good show. I don't rightfully know.
Okay, all right, but you understand that child support would have to be set. Now, are you asking for the issue of that child support to be reserved? And then, you're asking the court to award you a divorce from your wife on the grounds of inappropriate marital conduct, plus you being separated for 2 years, is that right, Your Honor? And how are you, how are you related to Mr. Dabbs? All right, do you know him to be a truthful and honest person?
Yes.
And do you have some personal knowledge as to what he testified to before?
Yes.
That's all I have. Sir, you can step forward. What is your name? And how are you related to him? His dad, all right. And do you know him to be a truthful person? Okay, all right. You have some personal knowledge of what he testified to. Your Honor.
All right, Mr. Dabbs' motion for default is granted. He'll be awarded an absolute divorce on the grounds of inappropriate marital conduct. Personal property will be divided as said. And then you said you wanted to sell the,
Sell the trailer. It's just the trailer, Your Honor. They do not own the lot.
all right. Then that will be, your motion to sell that personal property will be granted. And his proposed parenting plan will be adopted. So you'll prepare that. In the absence of any proof, though, I think I'm required to set it according to minimum wage R2. And I think that's what we would do, set it at minimum wage. All right. Thank you.
Case number 19972, Kim Michelle White versus Jeffrey Daniel White.
This sound is not working, and it's not going to work for these people on Zoom because I don't think they can hear us. I don't know why the sound's.
I got it on. I got it to light up. I pushed real hard.
You got
I'm
it
a button pusher.
well, you got it to light up, but it's not picking up any
Oh,
sound. So.
sorry. What is lit up? I don't know how to adjust the volume. So,
All right,
and-
all those who are going to testify, raise your right hand. Let's place you under oath.
yes.
Look.
Now you understand you have to speak loudly because of the
Okay.
program, okay? Please state your full name for the court.
Kim Michelle White.
You came to my office more than 60 days ago and filed a complaint for divorce. Is that correct?
Correct.
Is the information stated in that divorce complaint still correct today?
Correct.
You're
Yes.
not living with your husband as husband and wife, correct?
Correct.
And you're still asking for a divorce.
Yes.
You don't believe there's any chance of you reconciling.
Absolutely not.
Okay, you allege that he was guilty of inappropriate marital conduct. Is that correct?
Correct.
Was he physically abusive of you?
Yes.
And did he assault you?
Yes.
Okay, so are you asking the court to award you divorce based on inappropriate marital conduct?
Yes.
You've been married 5 years. Is that correct?
4.
4 years, going on 5. This
Yeah.
is the 5th year. Okay, and you owned real property before the marriage. Is that correct?
Correct.
And you have paid that mortgage,
Correct.
and he was never added to it.
No.
So you're asking that you be responsible and receive sole ownership of the real property. Is that correct?
Correct.
Now at my assistance, you have prepared a division of marital assets. You said there's a few items at the home that belong to him, correct?
Correct.
That being an entertainment center with stereo equipment, desks, 2 monitors, office chair, and other miscellaneous items, miscellaneous office items, clothes, shoes, radio tower, 4 tires, and wheels. Is that correct?
Correct.
And you are asking the court to award him those items.
Correct.
And you're asking that he have 30 days to remove them from the residence. Is that correct?
Yes, please.
Okay. And after that time, he will have abandoned them, correct?
Correct.
Okay. Now, is there any debt that's in both names?
There is one loan that he might be on for renovations,
But
I'm paying it. Yeah,
and so you would be solely responsible for any debts with marital residence, correct?
absolutely.
Okay. And you own a 24 Ford Maverick, correct?
Correct.
And he owns a 24 Toyota Prius. Is that correct?
Correct.
You're asking each of you take those items and be responsible for any debt that's on those.
Correct.
You are not asking. You're asking to be restored to your maiden name of Kim Michelle Knapp. Is that correct?
Correct.
You're asking that he be responsible for the debts in his name and you responsible for the debts in your name.
Correct.
Okay. And as far as retirement account, you have a retirement account, correct? But you've only been married 4 years. Is that correct?
Right.
So you're asking that you be responsible, that you receive ownership of that account. Is that correct?
All right, you want to put on your other witnesses?
I do. Please state your name for the court.
Diane Hamilton,
How long have you known Miss White?
58 years.
Do you know her to be a truthful person?
Yes,
You know what she said today to be true and correct?
yes.
Ma'am, please state your name for the court.
Sherry Beeman,
And how long have you known Miss White?
60 years.
And do you know her to be a truthful person?
Yes,
Do you know what she said today to be true and correct?
absolutely.
Your motion for default will be granted. We have 7.
Your sounds. Oh goodness, we did too. Thank you, Your Honor.
Thank you.
I'll get you a copy later. Okay. Okay. So we can go. You can go. Have a good day.
Figure out what it was. All right, call the next case.
Case number 19965, Ryan Upchurch versus Gregory Shepherd.
Good morning, Your Honor.
Good morning.
Tia Bailiff on behalf of Mr. Upchurch. We're here on my motion for default judgment and for attorney's fees. Your Honor, we filed a complaint on April 27th of 2026. The complaint was served April 28th of 2026. Mr. Jacobson filed his notice of appearance on April 29th of 2026. On June 2nd of 2026, we filed our motion for default, and no request for relief from timeframes for the rules of procedure were requested at any point prior to us filing for a motion for default or even prior to today's hearing. The appropriate time to have done that would have been prior to the motion for default being filed on June 2nd. But honestly, Your Honor, any time from June 2nd up until our appearance, he could have requested time to extend, but it didn't happen. So pursuant to Tennessee Rule of Civil Procedure 12.01, answer is required to be provided within 30 days of the petition being served. In accordance with Pash Industries, LLC versus Wallace Hardware Company, 2003 Tennessee App Lexus 802, it says a defendant shall serve an answer within 30 days after the service of the summons and complaint on him. It further states that the belated filing of an answer is not an adequate response to a motion for default. There must be some application to the court for relief from the failure to timely file an answer. In Pash Industry, in that particular case, The defendant was served on September 9th of 2002, and a motion for default was filed 11/1 of 2002. The answer was then filed 18 days prior to the hearing on the motion for default, and the default judgment was granted. The motion to set aside the default was denied on the basis that it is not curative, that the belated filing of an answer, and certainly that it was willful conduct that led to the untimely filing. In Harris Building Group Incorporated versus Tennessee Electric Incorporated, 2019 Tennessee App Lexus 293, the court addresses specifically what willful conduct is in failing to file a timely answer. It says willful conduct includes deliberate choices and conduct that is flagrant and unexplained. And Your Honor, if it would help, I did print these for the court so that you could follow along if you needed to. On Harris Building Group, on page 4 of that opinion, it talks about the deliberate choices and conduct being flagrant and unexplained. And it says, where a record lacks an explanation for a flagrant violation of the procedural rules, the conduct is willful and therefore ineligible for relief on grounds of excusable neglect. The conduct was willful when the defendant failed to file a timely response to the petition, despite being fully aware of the court proceedings. In that case, the timeline is much like the one here. It was served on July 5th. The motion for default was filed August 11th. And then the answer was not filed until months later. APAC ATL Inc. versus Morton is much of the same, Your Honor. The contractor failed to answer until the day before the scheduled hearing on the motion for default, in a hearing almost 4 months after the service of the complaint. That is directly what happened here today. An answer was filed at the 11th hour on Friday, July 24th of 2026, almost well over 3 months after the service of the complaint. And in this particular case, there was no extension request filed. There was nothing before the court that indicated that there was anything but sitting on their rights. The Court of Appeals is quite clear also in Myers versus Myers 2010 10 App Lexus 765 that were this court to grant the default judgment for failing to obey the rules of the Tennessee Rules of Civil Procedure and failing to file an extension, which the case law yields they should, and actually yields they must have prior to filing this answer, that the Court of Appeals would absolutely uphold any decision for a default judgment that this court would enter. And in our motion, we specified and redirected to the complaint exactly what the relief was that we were seeking. Thank you, Your Honor.
Good morning, Your Honor. John Jacobson. I'm sure Your Honor's not seen the declaration that we filed this morning on my behalf. I've brought a copy for counsel and for the court.
I'm sure if it was filed this morning, I have not.
Yes, sir.
It, so. It is in the file, so I'll look at the one in the file.
Your Honor, and most of those facts are undisputed. The nuance here is this was filed in late April, I think the 27th. The plaintiff sought ex parte TROs, I believe the day the complaint was filed and the following day. I'm not certain because there were no orders entered on that, but I was advised by plaintiff's counsel that the court denied those. I entered an appearance, sent an email asking that the plaintiff preserve documents, and the whole, I think the catalyst for this lawsuit, this docuseries that my client posted on social media outlets, started the last week of April, and as I understand it, the last of 4 episodes was published on sometime in late June. The counsel did file a motion to compel. I did, in fact, though, email her in mid-June about the schedule. And there's another client in a case that is not related, but it's another former employee of plaintiff, that she had asked me in an earlier email if I represented him and was authorized to accept service for him, which I had informed her I was. I never received anything on that either. I emailed her in June and to ask about the schedule on filing and answering the case, and whether or not she had filed this other case and had tried to serve anything on me. I received no response. I called once in early July, received no response, and sent an email Friday and received no response. So it wasn't as if we ignored this, Judge. And while this started out with a bang, with this request for extraordinary relief, nothing has happened in the case since, Your Honor. Plaintiff has not sought to take any discovery, served any written discovery. And frankly, when the motion for default was filed and the hearing for the motion was set on the 27th, I assumed incorrectly that if we filed our answer by then, that we would resolve this motion for default. And that's the mistake here, Judge, but there is no prejudice. They've done nothing to push this case in the interim. And we would ask, and the cases are in both the Tennessee Supreme Court and Court of Appeals, Your Honor, as you know, in all three sections have routinely held that defaults are generally disfavored in Tennessee. Cases should be heard on the merits. There is a case, a Tennessee Supreme Court case, Your Honor. It's the plaintiff's name was Youree, Youree, in which a default judgment was entered in Davidson County. The middle section set the default aside. The Supreme Court affirmed because in that case, the cause of action was a piercing the corporate veil, and the court found that the allegations in the complaint didn't even support that cause of action. There are at least three causes of action in this complaint, Your Honor, that we submit have the same problems: fraud, intentional interference with business relations, and unjust enrichment. None of those make sense in this context. And so for those reasons, Your Honor, we ask the court deny the motion. We're happy to enter a scheduling order, Your Honor, whatever we need to do to move the case along, but do not think default judgment's appropriate. Thank you, Your Honor.
If we have a response.
Yes, Your Honor. I think it's indicative that the declaration was filed the day of the hearing. And for the first time, I saw it while sitting in front of you. That is part and parcel of what's happened in this suit. The catalyst for a lawsuit is not a docuseries. It's a breach of a fiduciary duty. It's intentional infliction of emotional distress, unjust enrichment, and several other claims. To say that nothing has happened and discovery has not been filed, it would be because the defendant failed to participate in the suit appropriately. It would be absolute malpractice and a waste of my client's money to shoot in the dark on a 44-page complaint to seek discovery for every individual thing if they were simply going to admit to it. So that argument doesn't really hold water.
Well, let me ask this question. Excuse me for interrupting.
Yes, sir.
Mr. Jacobson, in his declaration, indicates that he has been in contact with you regarding this case and has notified you that he was involved. According to this, he said he emailed you, or rather you emailed him on May the 11th. He had noticed that he had entered a notice of appearance on April 29th. And then it says basically that there was no action taken between May 12th and June 2nd. And so I'm asking, were you aware Mr. Jacobson was involved in the case? And do you have contact with him?
Your Honor, absolutely. But the way that was represented was not accurate. To be clear, I was aware Mr. Jacobson existed because the day after his client was served, he filed a notice of appearance in your court. So he's been on the case since April 29th and not filed an answer. The way that he represented it would indicate that potentially we had some kind of meaningful communication related to this case, which we did not. The email that he's discussing is related to someone who has not yet been sued. We have not decided whether we are going to sue. That was a former employee that when I tried to speak to them to relate some of the concerns that we had, they said that they were lawyered up by Mr. Jacobson. So before we took any action, I wanted to ensure whether that person was lawyered up. He did not communicate with me related to Mr. Shepard in a way that I was able to receive at the time. I'm not certain if this court is aware, but I recently underwent emergency brain surgery. Be happy to show you. I have been out of the office as a result of convalescing for brain surgery. In fact, this is my first court appearance back, Your Honor, and I'm happy to see you. I'm happy to be here.
I'm happy you're here.
So I did not receive any communications from Mr. Jacobson, but I was very clear in my motion for default judgment. And in that clarity, I specified that a late filed answer would not do the trick here, that according to the laws of the state of Tennessee and the Tennessee Rules of Civil Procedure, a late filed answer just would not cut it. The rules say shall file. And then the case law says if for some reason you cannot comply with Rule 12.01, it's very simple. All you do is you file a request with this court, and this court has discretion to grant an extension of time. Not me, Your Honor. I don't have that authority. This court does. So my motion for default was clear in what the intentions were, which was don't sit on your rights. Let's move this thing forward. And honestly, I would never do discovery that rapidly on a case when it's a 44-page complaint. I just don't think that would be prudent for my client. I think that would not be a good steward of his finances.
Well, this is a situation where obviously it's a conflict of the plaintiff's position and the defendant's position, but it boils down to whether or not the court should grant a default judgment, even though an answer has been filed, albeit late. And certainly Ms. Bailiff has made a compelling argument that the case law is clear that appellate courts will uphold this court in ruling that a default judgment should be entered. The difference that I see in this case is that Mr. Jacobson has made known that he was involved in the case, and apparently from his declaration alone indicates that he was attempting to have contact with Ms. Bailiff. Ms. Bailiff obviously had reasons to be out of the office, but that he, in his declaration, states that between May 12th and June 2nd, the plaintiff took no action, that the motion was filed on June the 2nd. On June the 23rd, Mr. Jacobson says he emailed the plaintiff's counsel advising her he had not seen anything from her regarding Trevor Broad and suggesting a schedule for filing the defendant's answer to the complaint, but there was no response because she was out of the office, obviously. It is this court's opinion, and I think that case law is clear, as Mr. Jacobson said, that cases should be decided on their merit rather than on technical issues, and default judgments are not favored based solely upon the fact that Mr. Jacobson was involved in the case and made known his appearance, and apparently there was some miscommunication, misunderstanding on his part regarding the status of his filing an answer because of his contact with Ms. Bailiff and Ms. Bailiff having been out of the office. That I find that the late filed answer should be admitted and the motion for default should be denied. Ms. Bailiff will be entitled to file a request for attorney's fees for her appearance in the preparation of the motion for default and for her appearance today. Ms. Bailiff, if you'll file that, I will approve.
Thank you, Your Honor.
Thank you, Your Honor. Would you like me to draw an order?
Yes. If he's in jail, let's see if we can get him in here. Are they going to bring him in, or is he going to come in on Zoom? Okay. Just go ahead and bring him up, and then when we get him here, we'll take it up. Just let us know when he's here. We're going to skip over the Tammy Doris versus James Doris because Mr. Doris is in jail. As soon as we can get him up here, we'll come back to it. Go ahead and take up the next case.
Case number 4202, the state of Ruth Catherine Allison.
Good morning, Your Honor. This is a request for exception to claims in regards to the Allison estate. There are 4 of those. There's one for $130, one for $255, one for $27,407, one for $7,601.
Anyone here to represent Centennial Medical Center to prosecute their claim? No one here to prosecute. Your exceptions are granted. So.
19986, Tristan Stewart.
Have a good day, sir.
Well, if you'll raise your right hand, let's place you under oath.
Yes, ma'am.
You have filed a petition to change your name. I need to ask you a few questions under oath. Are you asking to change your name to avoid criminal prosecution?
No, sir.
Are you asking to change your name to avoid your just debts or creditors?
No, sir.
And it states here that you want to change your name to Tristan Douglas Hanson. Is that correct?
Yes, sir.
You have an order prepared that I think you submitted and looks like you've signed off on it. So I will approve your name change. You'll need to get a copy of this a little later in the day once it's been transmitted to the clerk. Okay.
Yes, sir.
All right. Thank you.
Thank you, Your Honor.
Case number 19984, Corey Goins versus Jennifer Goins.
Both of you raise your right hand. Let's place you under oath. You are Corey Wyatt Goins.
Yes, sir.
Mr. Goins, you filed a complaint for divorce using a form the state provides online to individuals wishing to represent themselves. Excuse me. That form contains certain statistical information. Is all of that information true and correct?
Yes, sir.
Pardon me. You've also filed a marital dissolution agreement that purports to bear your signature and that of your spouse. Is that your signature?
Yes, sir. Yes, sir.
Do you believe that agreement fairly and equitably divides all of your property and distributes all of your debts?
Yes, sir.
Is there anything between you and Miss Goins that's not addressed in that?
No, sir.
You are Jennifer Goins, is that correct?
Yes, sir.
Miss Goins, is that your signature on the marital dissolution agreement?
That is correct, sir.
And do you believe that agreement fairly and equitably divides all your property and distributes all your debts?
Yes, sir.
Anything between you and Mr. Goins that's not addressed?
No, sir. I do believe my name changes in there as well.
Your name changes, I think, a part of that agreement. You need to prepare a final decree of divorce. Have you done that?
I think so. I have these two. I think it's this one that I need to fill out, but they said to wait to fill that out until today.
Okay, so you have the form, but you've not filled it out. Is that correct?
Yes, sir. The final decree with marital dissolution agreement form 6.
Right. You need to fill that out, and then you can file it with the clerk downstairs, the Chancery Court clerk.
Okay.
And both of you need to sign off on it. Make sure it's completely filled out.
Okay.
And then just leave it with them, and I'll sign it later today.
Yes, sir.
All right. Thank you.
Case number 19766, Deborah Ann Tackett versus Jimmy Dustin Jones.
Your Honor, I'm not
currently an attorney of record in this matter, but I am going to be representing Ms. Tackett moving forward. We just worked that out this morning.
Well, this is a motion for default judgment. And Ms. Tackett was representing herself pro se when she asked for that.
Yes,
So
Your Honor.
how do you want to proceed on that?
We're ready to move forward.
All right. Is this Mr. Tackett?
No, I am Jimmy Dustin Jones's father, and I'm here to let the court know that he is incarcerated today, and he gets out Sunday. If we could move this to next week or week after to give him time to get over here.
Your Honor.
Come up. Sir, come up just so I can make sure I understand you. You stand at the podium.
Okay.
It's my understanding you're the father of the defendant.
Yes.
All right. And you've said that Mr. Jones is in fact incarcerated.
Yes.
Where?
In Robertson County.
Okay. And why is he incarcerated there?
Failure to appear and violation of probation.
All right. And you're asking on his behalf to move it to another day to allow him to have time to hire an attorney?
Yes, sir.
When is he scheduled to be in court?
Over there. Oh, he's already went through, and they give him so much time, and he got on the program there where he gets day for day, and so he gets out. His release date is August the 2nd, and he's done over there. All his fines been paid and everything.
Your
All
Honor.
right. You can have a seat, sir.
Yes.
Thank you.
I think that you can see in the file that the defendant was served a year ago nearly. At the time that he was served, he was not incarcerated. So from July until March, he was not incarcerated, did not file an answer, did not participate in this divorce. So we would ask that he be found in default today and this matter be allowed to continue forward. For the record, they have no children and no property. This is just a divorce.
Well, that's my review of the court file indicates that there are no minor children and it does not allege that there is any marital property to divide. So it's basically just granting a divorce or not granting a divorce. The court's review of the file indicates that he was in fact served. This case has been pending over a year and that he was served, and therefore I will allow you to proceed on your motion for default. If Mr. Jones has some objection to what the court does in this case, then he has the right under the rules to file a motion within the specified period of time. But we're going to go forward with it today.
Thank you, Your Honor.
All those who are going to testify, raise your right hand and place yourself under oath.
Yes.
Okay. Can you tell the court your name?
Deborah Tackett.
And you filed a complaint for divorce on your own, is that right?
Yeah. Yes.
And since then, your soon-to-be ex-husband has not participated in that or called you or tried to settle anything with you.
No.
And as of today, everything in that complaint is still true.
Yes.
You're still separated and you're asking for a divorce.
Yes.
And isn't it true that you have had an order of protection to protect you from him in the past?
Yes.
And so you're asking today that you be granted a divorce based on his inappropriate marital conduct.
Yes.
All right. That's all I would have, Your Honor.
And there is, I believe she's testified, there's no property in.
Sorry. Yep. Let me ask you that. Y'all don't have any home that you own together?
No.
You don't have any minor children?
No.
You don't have any joint debt?
No.
And so you're asking that everything that you have in your possession is yours, anything he has in his possession is his, any debt in your name is yours, any debt in his name is his.
Yes.
And you're asking that you have separate car insurance, health insurance, and cell phone.
Yes.
All right.
Thank you. You can step over to the side. Can you tell the court your name, please?
Hannah Jones.
And Hannah, how do you know Miss Tackett?
It's my mom.
And do you know her to be a truthful person?
Yes, ma'am.
And you heard everything she said today?
Yes, ma'am.
And you know that to be the truth?
Yes, ma'am.
That's all I have. Can you tell the court your name?
Caitlin Newland.
Miss Newland, how do you know Miss Tackett? She is a family friend. And do you know her to be truthful?
Yes, ma'am.
And you heard everything she testified to today and know that to be the truth?
Yes, ma'am.
All right. Plaintiff will be awarded an absolute divorce. She'll be restored to her maiden name, or she doesn't have a maiden. She's
You
not
can do a name change.
adopted that married name. And anyway, she'll be awarded a divorce on the grounds of inappropriate marital conduct and awarded all the property in her possession. Each of them will pay their own debts.
Thank you, Your Honor.
Okay. Yeah.
Case number 19821, Tammy Doris versus James Doris.
Morning, Your Honor.
Good morning.
Here for the plaintiff, Mr. Newsom, said petition to amend the final decree of divorce. Divorce was finalized by agreement, irreconcilable differences back in March. Part of that marital dissolution agreement divided a retirement account.
Well, I think we may be on a different case than what you were talking about. You're calling
It's called
the
Newsom
Doris
versus Newsom.
Doris.
I'm sorry, I can't hear all the way over there. I'm about to relocate.
Try. Doris versus Doris. Tammy Doris versus James Doris. Ms. Brady, that's your case.
Good morning, Your Honor.
Good morning. This was reset for today, I think. I'm not sure exactly. I remember that Mr. Doris appeared when he was in custody, and it was reset for us to determine the distribution of real property owned by the parties and whether an award of alimony is appropriate. Should you amend your petition? Have you amended your petition?
Yes, Your Honor.
All right. Then you may put on your proof. If you'll raise your right hand, please.
I do.
Okay.
All right,
Miss-
let me stop you for a moment and state that you filed an amended complaint for divorce, which means we cannot grant your divorce today because he has 30 days from the filing of and the service on him of the amended complaint. So
Okay.
it restarts the time that he has to file an answer. So I don't know if that makes a difference in how you want to proceed or not. Has he been served with that amended complaint?
It was sent to him in jail. So we didn't do like a summons or anything like that.
Once he was served, you can serve it by mail.
Right. And that's where we sent it to him in jail.
Well, let me just point out that when you file the amended complaint, which you have every right to do, and I understand why you would, and serve it on him, he has 30
Sure.
days to file his answer. So I can't grant a default.
Sure.
And I would suggest you just reset it for next month, and that way we can go from there.
I concur, Your Honor.
Thank you.
All right. Thank you.
What date? Let's go ahead and set a date, Ms. Brady.
Sure. That's fine. I'll get a date, Your Honor, and put it in the
All
order.
right, thank you.
Thank you.
I'm on my third set of antibiotics for this, and they're still knocking it out. So
Case number 19894, Arthur Newsom versus Donna Newsom. Donna, we can't hear over here. We apologize. We can't hear.
is that because of the air conditioning?
We can hear you. Yeah, we can't hear the clerk.
Oh, you can't hear the clerk because I can barely hear her. She needs a microphone of her own.
I thought she had one.
How about this? I will repeat the name of the case after she calls it to me.
That would be most helpful, Your Honor.
All right.
This is Miss Newsom.
Arthur Roy Newsom versus Jr. versus Donna Lee Newsom. Everybody hear that one?
Yes.
All
Apparently, Miss Newsom is here. Now that I've already briefed you on the case, we're here on a petition to amend the final decree that was done by agreement regarding a retirement account. Miss Newsom was awarded $350,000 from my client's TSP. thrift savings plan. However, that money was shifted to an IRA before the divorce was finalized, and therefore he cannot access those funds from first command without an amended final decree of divorce that I prepared. Ms. Newsom has signed an amended marital dissolution agreement. I don't think there's any opposition to this motion being
You
granted.
want your money, right?
It's taken a long time, and I'm getting overdrafts and all kind of things.
Well, we're going to try to take care of that today.
Thank you.
Mr. Biggs, I have signed this final decree, this amended final decree.
Very good. Thank you, Your Honor.
Hopefully that'll take care of you, ma'am.
Can I get one today?
Case number 19828, Olivia Jackson versus John Jackson.
Your Honor, there's a preliminary issue that the court has to address. My client had filed for the divorce. Ms. Tackett from Robertson County was representing the husband. I filed a motion to compel the discovery because they weren't answering it. Then on the same day I came to court on the motion to compel, his attorney filed and heard a motion to withdraw. The court allowed him 30 days to get a new attorney. I reset my motion to compel and my motion and did a motion to set for final hearing. Your Honor granted my motion to set for final hearing, and we set it for today. Last Friday, evidently, he re-retained Miss Tackett. Miss Tackett sent my office a message. It was Thursday or Friday. Forgive me, Your Honor. Sent me a message, said she was re-retained, and I said, have him sign the MDA. These parties have nothing but debt. That's all we're dealing with. And she then told me that she couldn't be here this morning, that she had to be in Robertson County. My client wants to get this done and over with. All they've done is prolong it. They've not done anything to get it over with. And him retaining an attorney and not even telling her it was set today on within 2 days of the hearing is just not reasonable. So we're asking that her motion to continue it be denied.
One of the problems that I have is that I practiced law for a long, long time, and I know how sometimes these things act. I understand your need to get this thing heard, and I understand that there is very little to fight over, but I'm reluctant to take advantage of an attorney who's just been brought into the case. So I'm going to grant the motion to continue, but I will order that it be set for the first available date that you are available, and she'll just have to make her arrangements. If she can't be here on that day, then you will have the right to proceed, and she'll have to either find someone that's a surrogate for her, or she'll have to be here.
I understand, John. I'll get with the clerk.
All right. Now,
Thank
we're
you.
going to try to take care of it as quickly as we can, but I'm going to give them an opportunity to be here. All right. Thank you.
Thank you, Your Honor.
Case number 19703, Pamela Mitchell versus Anthony Mitchell.
Pamela Joy Mitchell versus Anthony Keith Mitchell. I dropped down on my agreement to repeat that. It's here for an order of protection.
Yes, Judge.
Are we ready for a hearing?
We are, Judge.
Yes, Your Honor. And Your Honor, I hate to be difficult, but I can't see. If we're going to use the witness stand, I can't see
You
over
can't
this.
see. Is it because you're short?
Well, Your Honor, for the record, opposing counsel is a lot taller than I am. So
I can switch. I don't know if I'll be able to see either. But also, Judge, I think this is going
How
to take.
about that? We have the witness stand on camera, so you will be able to see the witness stand, and I will turn off.
Okay.
There you go.
Okay,
Is that helpful?
maybe.
Or what do you want? How do you want to do it different, Ms. Nolan?
I would like to have this table if I could.
Switch tables with her. There is such a thing as a high maintenance lawyers.
That's what my husband says, Your Honor. Your Honor, this may take a while. I'm not sure if the court wants to hear this now, or if you want to move to
Let me run through the rest of the document with your agreement to see if there's anything short we can dispose of. So, and then we'll come back to you. We'll take you up as the first contested matter.
Thank you, Your Honor.
Excuse me.
Case number 19841, National Electric Company versus All About Electric.
National Electric Company LLC versus All About Electric. And Sean Christopher Geary.
I represent him, Your Honor.
All right.
Your Honor, Greg Oakley, I represent the plaintiff.
And how long are we anticipating this is going to take for a hearing?
Well, Mr. Kraft filed a Rule 60 motion on Tuesday, which I replied to on Saturday. I think that may take 15 or 20 minutes. And then we have a couple of other motions that I have on the docket. Depending on what happens with the Rule 60 motion, should only take 5 or 10 minutes.
All right. Let me run through the rest of the docket. We'll come back to you. Sandra Nicole Hodge Steverson versus Jason Allen Hodge Sr. That one was continued. Is that correct? Philip Crandall Brown versus Shelby Lynn Squires. That's for hearing.
Well, Your Honor, I had filed a motion, fax filed a motion on Friday afternoon because I wasn't aware this was set for a final hearing. When we appeared last time, we were here on the emergency request. I've sent out discovery the next day. When Miss Selena's office got involved, we found out it was set for a final hearing. We've not had time to get the responses back, nor are they even due yet. That's not a fault of Miss Squires by any means.
Ms. Selena, you're the guardian ad
I
litem.
am.
I appointed the last go round.
That is correct, Your Honor. And I was a little confused as to whether or not this was a final hearing. And then it was my understanding that it was set for a final hearing. So I had just mentioned it to counsel for the father that I thought it was set for a final hearing. So I think there is an issue though that probably needs to be addressed. And you filed a motion on the
First
school
of all,
issue,
my
right?
client is not here. He had been under the impression that I would be allowed to appear by Zoom. I figured out some childcare arrangements and was able to come in person. But he is doing that music festival. He wrapped up about 7 or 8 p.m. last night in Indiana. So he thought he was going to be allowed to appear by Zoom also because I was going to be allowed to appear by Zoom. So if the court wants to take up the motion regarding the school enrollment, because the children need to be enrolled in school somewhere. They were enrolled in Cheatham County last year. Neither parent's living there. We've got to get them in school somewhere. So that's why we wanted to move this forward and get a date before school. I had no clue the court was thinking that would be a final hearing. Thought that
I'm
was
not sure that this court thought it was a final hearing. I'm not.
okay. Well, then we
Well,
may
and
have gotten a little worked up for nothing on that.
Well, and I may have, you can't.
She, the Squires she's one of the parties, so she needs to come over here. Just the Squires, if you'll come over here and have a seat at the table until I can sort through this.
My client is happy to get on by Zoom. He's sitting on standby.
And it was set for something today.
I did.
So Judge Turnbow set the initial hearing for July the 7th after hearing some matters.
And I'm not sure if the court's looking for an order from the last hearing, but I sent one in. We've just not received it back yet.
And that's what I was looking for, but I do not find
I have
it
a
ordered,
copy
been
of
ordered.
what I had mailed in.
Is that the from July 7th?
Yes.
I actually have,
Has it been signed?
yes.
I didn't get a
just,
signed copy back yet.
yes, I have a signed copy. So it should be in the file.
All right, I'm gonna hand back the unfiled one and look at the file.
See if it's the same issue.
Well, this order resets the hearing on the request to relocate with the children on an emergency basis and your motion to enroll the children in Cheatham County Schools. So that's what has been reset for today. And if you wish to go forward on that without your client being present,
We do want to move forward on the school enrollment motion. My understanding, my client's understanding was the hearing that took place on July 7th was just on an emergency basis. Should this be granted? You didn't grant that, but you did continue the hearing to appoint the guardian ad litem. And we also had a pending motion that day that wasn't heard. So we thought that was what was being continued to today.
all right, let me take some short recess. I'm gonna take a look at this file and we'll come back and tell you what I think.
All right. Court is in recess.
I enjoyed your highlights. I enjoyed your highlights. Right.
Oh, he's been
My husband now told me I'll make this sort of fireplace. He's removed all the drywall, wood up covering, but you can actually see the wood coming in from the plywood around the place. And he's in it. It's so hard. Never produced any speech. I showed him. Yeah, the table's crooked. You can't get through his road.
Trial up here, somebody turned it like that, trying to do what they wanted to do.
I can say a little thing in shut, but not
If they had to put the witness stand over here, you would have still had the same problem with that thing.
I ended on their words because by the middle of the year, they had decided she qualified for RTR and they were going to need such a full day. So it's overlapping with the outside services. She was in there.
Anybody that has to use the court.
20 minutes up.
Had a services or something. Every day. And to this man, I don't have this much room. To the church. And that's about what happened.
We got a brand new door that does have a, and there's a hole.
So the general session court wrote the same thing. You let it go, it's allowed.
Allison, Judge Barker, he was always picky about that gate.
As well, there
She still thinks she does have some friends.
it's letters that stick on there, do not let gates
She's the
slam.
oldest, right? Yes, she's
Her out loud, you tell her, you let it go. In the home.
And it's crazy. It's freezing. She
It's
is
warmer than it has been.
being
Trust me.
in the bathroom. They're like, we could hang meat. We could hang meat in the bathroom. She loves me.
It used to be in there. It was cold, like 67. I don't know what it is now, but the first time we had court over here, it was freezing.
Yeah, I'm not very impressed with that house. Because the house is to expect to see so,
66.
If they're not at the house, then he does need to take them out to the mall. Most nights he's taking them up to the filling station, Dickson Springs, because that's his new car. So I feel like he can do some stuff, but it's more.
I think he likes it. It's just
He does love them, but I feel like the biggest problem is that he's still so frustrated with things that not making any sense. Just
Yeah, they gotta do something in the game. A lot of business.
of course they could go. They've never been.
It's too tight. Yeah.
I saw your email. Did you bring extra hard copies or was that yours? No, that's fine. I can look at it on here. That's fine. No, you're fine.
So you have the email
Of what she filed.
Okay. So you filed. So you have how many copies do you file? You have one in the court file. I handed upstairs.
This is worse.
And then you have this one. And then you have three. Two.
Yeah, mine too.
Let me just read it.
It's not something most people do. In that right door.
What am I saying? It's right. Right too.
I was telling her.
Oh, yeah.
That enjoy it.
Yeah, no, I would say
Yeah.
that.
I've had a couple of. I thought they had a little bit.
I don't enter.
No.
That's a lawyer.
No. Yes. I was. Yeah. Yeah. All rise.
Please see.
Back in session, you may be seated.
All right. My review of this file indicates that the order that was put down did not reset this for a final hearing, but rather was just resetting the motion for the children to be enrolled in Cheatham County schools, because I had already made the determination at that prior hearing that there was not an emergency basis for the relocation of the children that Ms. Squires had requested without a full evidentiary hearing. And for that reason, I appointed the guardian ad litem so that there would be an opportunity for a full and complete hearing. So this court is of the opinion that the hearing today would be on the enrollment of the children at Cheatham County schools, and whether that is advisable or not. And it would be limited to that issue.
Yes, sir.
So I have already assured another case that they would be the first case on a contested basis. So we'll come back to you. I took a break to look at my schedule to see whether or not there was an opportunity for this matter to be reset. Tomorrow is my final day here, and it's a criminal motion for our docket of VOP hearings. So we'll have to come back to you today, or it will be reset for some time, because I don't have any open days between now and the next time I'm here, I don't think. So, all right, we'll come back to you a little later.
Thank you, Your Honor.
Call the next case, please.
Case number 19214, Benjamin Novak versus Noah Myers.
Mr. Novak, you have an attorney named Margaret Chesney, is that correct?
Yes, sir.
All right, she is apparently coming in on Zoom, so. This is a petition for civil contempt and modification of the parenting plan, and just have a seat there.
Yes, sir.
Ms. Chesney, you represent the
Yes, Your Honor.
plaintiff in this case?
Yes, Your Honor, I do.
Okay. We're trying to get we're taking these matters up to get a handle on how long it's going to take for us to have a hearing in each of these cases. Can you give you and Ms. Davis give me an opportunity, or at least an idea of what you think it's going to take for this?
Well,
hearing?
Your Honor, we have our petition, and Ms. Davis has filed a motion for continuance. She's new to the case. While we don't necessarily oppose a continuance, we just need to address the court on some issues, because we need a temporary parenting schedule going forward if the continuance is granted. And so I don't know how long the court would need to hear from us about that.
We'll need to, yes, if there's a motion to continue, then we need to, obviously, to address that. We have a number of cases that are set in front of you that are for a hearing, and I was just trying to determine the length of time that this case would take. But if it's a request for a continuance, tell me, what are you asking? If I understand correctly, Ms. Myers has relocated to another state, and Mr. Novak, who is here in the courtroom, is requesting, according to the file that I'll review this morning, that some sort of a specific schedule be set for him to visit with his children out of state. Is that what I'm understanding?
Well, he would like to visit with the children in Tennessee. What he's asking for specifically today, Your Honor, is the 2 consecutive weeks of summer visitation that are in the parenting plan. We understand the mother is getting married, and we understand she's going on honeymoon. The parenting plan provides for the right of first refusal for when she's going to be gone for more than 12 hours without the child. So we're requesting that time, just specific time between now and whenever the rehearing is, Your Honor. And then the issue of relocation, transportation costs and shared transportation has arisen. My client has done almost all of the transportation going to Ohio to see the child. So we're asking that that be shared in this interim time, that they meet in a halfway point.
All right, Ms. Ms. Davis, you have any position on this? Obviously, is it you that's asking for a continuance?
Yes, Your Honor. I was retained last week on Tuesday. This case has got a lot of complications to it. The motion for contempt is very lengthy. I filed a response. I worked all weekend to file a response to the motion for contempt and filed it last night, which is not very much notice for anybody, and I apologize for that. But I haven't even had the chance to go through all of the information my client has sent me, which is voluminous messages between herself and the father. I'm in Davidson County this morning and have a final hearing on a child support matter that has not started yet. I think that even for the court to hear and to make a ruling on a temporary situation for parenting between the father and the child is going to take at least 2 to 3 hours. I do think that there needs to be a hearing. I do think that we need to do it sooner instead of later. But if you had the chance, and you probably haven't had the chance because it just got filed this morning, the child is 4. Father has had a total of 12 overnights with the child in the last 4 years. And there's been a lot of back and forth between the parties. They went to a mediation last Monday, were unable to resolve an interim plan. Father last had the child from July 10th to the 12th. 2 days has been the maximum he has ever exercised parenting time with the child. And I'm not here to stand for the proposition that dad's a bad person or dad doesn't love his child. I just think it's significant that my client has lived in Ohio for over 2 years, and this whole thing is just contested. So I don't think that to without hearing any evidence and having a hearing, to think that sending the child on a 50-50 plan to Nashville with dad is a good idea. And there's a lot of reasons for that. And I respect, of course, Miss Chesney's position. I know she's got to do everything she can for her client. I just need a little bit of time, and I've got plenty of dates. I don't know what the court schedule is, but I would love to be in person in front of you so that we can all be in the same room and we can have a hearing on this and make a decision that makes good sense for the child's best interest.
When's your next available chancery day, madam? Well, this is herein lies your problem. We have a number of cases set on the docket that are advanced or ahead of you that are probably looking to take the rest of the day. And if your case is going to take 2 to 3 hours, then there's really a little way that it's going to be heard today anyway. And I am of the opinion that it needs to be reset. I can tell you that it looks like the first available day that is open for resetting. We have 4 judges that cover 5 counties. We rotate in and out on a regular basis. This concludes my days of chancery here in Cheatham County for 4 months. So it would be advantageous for you to get in front of another judge, since I haven't, to my knowledge, heard any of this before. So I'm going to grant a continuance based on the fact that it's unlikely it's going to be heard. And I will simply observe that, and I will put this in the order that's drafted for the continuance. The final parenting plan that these parties agreed to is still in full force and effect. And that provides that the father have 2 weeks of summer visitation, 2 consecutive uninterrupted weeks of summer parenting plan. So if he has not had that this summer, he's entitled to it. And I'm in this order setting forth the fact that they're bound by the final decree and parenting plan that they entered into, and that will have to be a part of this order of resetting the case. So I can tell you that September the 11th is the first available date for a full hearing.
Okay.
Sorry, Your Honor, just give me 1 second. Your Honor, would I be able to attend that hearing via Zoom?
It's a different judge. Would she be able to attend the hearing in front of Judge Lockhart Nash? You'll have to contact Judge Lockhart Nash's assistant. The other date she has is what day? September the 13th, 30th.
Oh.
The 11th would be a much better day.
September the 11th works for me, Your Honor.
Works for me.
Who would I need to contact?
Judge Lockhart Nash is the judge in September here, and you would need to contact her assistant, who is Kelly Berryman. I've looked to see if there's any open days that I can offer to you in some of these other cases, and I simply do not have anything open on my calendar. So we'll reset it for September the 11th, and again, this order should reflect that the court finds that the original parenting plan, which was adopted, is in full force and effect.
Do you want me to draft that order, Your Honor?
Yes, yes, please.
I will. And Margaret, I'll call you.
Okay, thank you.
You're welcome.
Thank you, Your Honor.
Stay in touch with your attorney so she can work out when you're going to have that visitation, okay?
Yes, sir. Thank you, Your Honor.
Thank you.
All right, let's call the next case.
We've reached an agreement. You want to get rid of us, or we will.
I would love to get rid of you, so come on up.
I thought you might like that.
No personal
I
animosity
know,
there.
and I don't take it that way at all, Your Honor.
Which case was it again? I'm sorry.
Osborne, it's on the next to the last page.
All right, what is your agreement?
Well, the income, the Pendente light support, we're going to remain status quo. Everyone will continue paying what they're paying. Nothing's going to change.
Not moving any money, things like that.
Yeah, everything will continue on as it has. And as far as the motion for the educational testing, we've agreed that the children will take a standardized test. My client will be the proctor, and wife will not interfere. She will encourage the children to take the test, and any outcome of that test is reserved for a later hearing. And my client will get all this done within 30 days.
All right. If that is your agreement, then we'll
Is there
approve that
anything
agreement.
that I missed?
I don't think so.
Okay.
All right, thank you. Who's drawing the order?
I'll draw the one on the education.
I'll draw the one on the support.
All right. We'll have two separate orders.
Is that okay, or do you want them all in one? I can do them in one.
One be fine too.
Yeah, I can do it all in one if you prefer.
Let's just do one order. That just seems to me to be more advantageous.
No worries. I will prepare it and forward it over to council for review.
All right. Thank you.
Thank
Very good.
you.
Thank you, Your Honor.
Call the next case.
Okay, so P4162, instead of Irene Page.
Your Honor, this matter will be relatively brief. This is just a certification of a will contest. My client, Jeffrey Mays, is an intestate heir of the decedent, and we are just asking that our will contest be certified. I've brought a proposed order.
Anyone objecting to that certification?
I've been in touch with the counsel for the estate. He doesn't object either.
Then if you'll submit your order, that'll be, is it transferring it to circuit court for the trial?
No, sir. It's keeping it here in Chancery.
You okay with doing a jury trial? All right, I have signed your order.
All right, I appreciate it. Thank you, Your Honor.
So we go back. So we're ready for, I think, Ms. No and her case. If we had a Sears catalog, we'll have you sit on it. That might be helpful.
I'll try and bring a phone book or something next time.
This is the 2025 CR 19703 Pamela Joy Mitchell versus Anthony Keith Mitchell. It is a petition for an order of protection. Both sides are ready. You wish to make an opening statement?
I will briefly, Judge. Judge, this is our petition for order of protection. The parties are married. They are going through a contentious divorce. They've been married for 53 years. The petition alleges that the husband has been verbally abusive, cold and harassing. She also alleges stalking. He has showed up at places that he should have had no knowledge that she was at. They've also had a discussion about him placing a tracker on her vehicle, and she has the screenshot showing that there was a air tag placed on her vehicle. She at one point had a automobile accident in Davidson County, and it's going to be her testimony that the husband showed up at that scene of the accident before the police even did. There's pictures of him showing up at a friend of hers house and taking pictures of her vehicle in the driveway. While he was taking pictures of her vehicle, the security camera was taking pictures of him. So we do believe there's stalking going on, and this is elevated to the point where he calls her multiple times a day, calling her a whore and a slut and all this stuff. And one of the last voicemails says, "I hope you die." So it is escalating. He has numerous guns. She's afraid of him. So we're asking that the order of protection there is an ex parte in place. We're asking that it be continued as long as the divorce remains pending.
All right. Ms. No, you wish to make an opening statement?
Yes, Your Honor. Your Honor, the parties' divorce has been pending since May of 2025, so it's been over a year now. And Your Honor, I think it's kind of odd that no order of protection, no restraining order, nothing's been done until now. The parties had mediation less than or right at a week prior to this order of protection being filed. They were not successful in mediation. I feel that this order of protection is being done in a somewhat vindictive manner. A lot of the allegations complained of my client happened a long time ago when this divorce was first started. And I feel like to take out an order of protection now is just being done to be harassed. And my client, to be candid with the court, has maybe called her some names. And Your Honor, I don't think it's the first divorce that we've ever heard somebody call their spouse a name. I don't think that gives rise to a level of an order of protection. The parties have grandchildren together. There's a birthday party that's being planned that is upcoming for one of the grandchildren. And I think this is being done so that he cannot participate or be in his grandchildren's lives. And I think this is just done in a vindictive manner. And again, it's been pending for over a year. Nothing's been done prior to this. And we do have a plausible reason of how he got notified about the car accident. The parties had joint insurance and got notified by the insurance company.
All right. Judge, I called my client. She has voicemails that she needs to play. Can she bring her phone to the stand?
Yeah, she can bring her phone up there. There's a microphone on the stand. A little bit awkward. If you'll come right around here and have a seat. Ask you to please stand and raise your right hand. Face our clerk. Thank you.
Just state your name for the court.
Joy Mitchell.
You see that microphone right there?
Joy Mitchell.
All right, pull it down to you. We still can't hear you.
Joy Mitchell.
Better. Okay. And how do you know the respondent in the blue shirt here?
We're married
Okay. How long have you been married?
53 years.
Okay. And what brought you to the court to file this petition for order of protection?
These 9 voicemails.
Okay.
They escalated. The last one said he wanted me dead.
Okay.
And
All right.
I'm scared to death.
All right. I want to pass you a copy of something here. Do you recognize that?
I do. These are the copies of the emails on my phone screen.
Is that your call log?
Yes.
All those calls on the same day?
Yes.
Okay. And I'm going to also pass you
On June the 27th.
Okay. And that's of this year?
Yes.
And what is that?
That's the call log.
Is that the screenshot of your voicemails?
Yes.
Okay. And are all those voicemails from your husband?
Yes.
And 1, 2, 3, 4, 5, 6 voicemails in less than an hour's time. Is that correct?
9.
9 voicemails?
Mm-hmm.
Okay. Can you
The
play?
others were on a different page.
Okay, I'm sorry. Judge, can I make these first exhibit collective?
Right. I'll mark this as a collective.
Thank you, Judge. Ms. Mitchell, you have your phone there in front of you?
I do.
Can you play those recordings from the first one to the last one?
Yes, sir.
Okay.
I can.
Your Honor, I am going to object. We had discovery that has been sent, and these were not supplemented or provided to me in the discovery, so I'm going to object to their introduction today.
That's for the divorce case, Judge. This is a separate action.
It is a separate action, although it's been consolidated with the divorce action itself. And my understanding is on an order of protection, it's not necessarily required that they be provided to you in advance of the hearing. So I'm going to overrule your objection.
Thank you, Judge. Can you go ahead and play them from the beginning to the end, and just tell us when one ends and the next one begins if it's not evident?
All right.
And put the phone up to the microphone.
Hey, road whore, call me back.
Is that the first one? Is that the end
That's
of
the first one.
All right, play the second one, please.
Hey, road whore, answer your phone, you fucking slut. Suck you, I hope you die. Hey, road whore, are you fucking David Berry 2 years ago? You piece of shit. Hey, bitch, who's David Berry? Are you fucking David Berry, road whore? Was you fucking 3 years ago? You bitch. Are you fucking David Berry, road whore? Was you fucking 3 years ago? You bitch. Hey, road whore. You called David Berry before you ever left me. Who's David Berry, road whore? 1 a.m. in the morning.
Are those all of
That's
them?
the end.
Okay. Judge, I would ask that those recordings be made as a collective exhibit. I have them on a flash drive to make it easier for court.
Mark them as Exhibit 2. Just hand that to the court.
Now, Ms. Mitchell, I think you may have played some of those out of order by the call log. Was the last one he sent you the one that says, "I hope you die"?
That was the fourth.
The fourth one?
The fourth.
Okay, I'm sorry. When he said he hoped you die, how did it make you feel?
And Your Honor, for the record, I didn't get a copy of the flash drive. I mean, just to have a copy of the same
It
evidence.
made me feel
Overrule the same basis for the overruling of the objection. This is an order of protection, which is an extraordinary remedy, and therefore I'm allowing this evidence for that reason.
And Judge, just for the record, I want to make clear, I told Ms. Snow about these this morning and told her that I was going to play them. She never once asked to listen to them.
It's kind of made the day of, so.
How did that make you feel saying he hoped you die?
well. It's a sad state when you've been married to somebody for 53 years and they can treat you that way.
Did that put you in fear?
It does.
Okay.
And he has a gun safe full of guns.
Okay. Has he been violent with you in the past?
Yes.
Okay. Tell the court about that.
He's pushed and shoved.
Okay. And did that put you in fear of him?
Yes.
Okay. Has he ever hit you?
Yes.
Okay. And when was that?
It's been a while.
Okay.
I don't remember the exact date.
Okay. But because of him being violent in the past, are you afraid of him now?
Yes.
Okay. Tell the court about the stalking. Do you believe that he's put trackers on your car?
I know he has because my iPhone told me that I was being tracked, and it even showed me where he was tracked. I was at the Veterans Cemetery putting wreaths on the veterans' graves.
Sorry.
In November.
Those are the same thing. One was for the witness. I apologize. There should be 2 copies there.
Thank you.
Do you recognize that?
That was the screenshot of my cell phone where I was being tracked at the Veterans Cemetery putting wreaths on the veterans' graves.
Okay. Now this says it's from December of 24. Is that correct?
Okay, yes.
Is it? Okay.
I was thinking it was November, but it was December.
Okay. Judge, can I mark this as the next exhibit? I think it's 3.
Marked Exhibit 3.
Now, has there been other times since then that you and the husband have had conversations about him tracking you?
When I was notified by my phone of this, I was concerned because I didn't know who was doing the tracking. And so I spoke with my children, and they said that
Don't tell us what the children said. I'm asking you, have you had a conversation about a tracker on your vehicle with your husband?
yes, and
Okay.
he bold-faced told me 3 times he had not done it.
Okay. So what did you do?
I was going in the house to get my purse in order to go to the West Nashville precinct to see if they could get the tracker out.
Okay. And what happened?
I called and they don't do that sort of thing.
Okay. When you tried to leave, did something happen?
He stuck his arm up in the back end of the car
Okay. And
was trying to pull something out.
okay. And when was this?
It was after I was notified. It says it's December the 15th.
So this was at the same time as this notification?
It might have been the day after because
But around the same time?
yes, around the same time.
Okay. Now, have there been other incidents where you would be at someone else's house and he would show up?
Yes.
Okay. Tell me about that.
I was helping a friend decorate his Christmas tree on Thanksgiving Day,
Thanksgiving of this past year?
Yes.
25?
Yes.
Okay. Do you recognize that?
It's my husband taking a picture of my car.
Okay. And where was this at? The friend's house?
Yes.
Okay. And did you tell him you were going to the friend's house?
I did not.
Y'all were already separated at that point, is that correct?
Yes.
Okay.
We had been separated since June the 1st, the day or 2nd, the day that he was served.
Would he have any knowledge, any way to know that you were at this friend's house on this day?
Not unless he had a tracker.
Okay. And is that him in the car?
It is.
Okay. And
that is his car.
Okay. Judge, it has to be marked next exhibit. 4. How did that make you feel where he showed up somewhere that you were without you telling him?
I didn't have any idea how he knew I was there or why I was there or why he showed up.
Okay. Did that make you afraid of him?
Yeah, because I felt like he was stalking me.
All right. Now, you heard what I said in the opening about the car wreck. Tell the court about the car wreck. When did that happen?
It was on March 13th. I had driven all the way back from Florida that morning, and I was going around a cul-de-sac. I had just left a Mexican restaurant, and I was going back to my apartment. And I was going through a roundabout thing, not a cul-de-sac, roundabout, and a car hit me.
Okay. And did you call the police?
I did.
Okay. And did your husband show up at that wreck?
He did.
How soon after the wreck did your husband show up?
Well, he got there before the police and the wrecker.
Okay. Did you find that odd?
I did.
Okay. Approximately how long after the wreck was it before he showed up?
15 minutes, maybe. It wasn't even that long, maybe.
Okay. And how far away does your husband live from where you had the wreck?
A good, at least 7 to 10 minutes, maybe.
Okay.
He lives in Pegram, and the wreck was in Bellevue.
Okay. So it is possible that if he were at home, that he could have made it to the wreck from the time the wreck happened and those 15 minutes.
Maybe.
Okay. Did he make any comments to you when he showed up at the wreck?
No, a friend of mine stepped in front of him.
Okay.
To separate him from me.
Okay. What do you mean by that? Was he coming towards you or what?
He was trying to get in the door, and my friend is rather large, and he stepped in front of the door to keep him from coming in. And my friend was kind of upset with him because he said he was trying to get in and see if I'd been drinking, because it happened right in front of a pub, and I went in because my friends were there. That's where they'd gone. I was on my way home. And they went in there, so I knew that one of them could give me a ride home.
Okay. So after the wreck, you went into the pub?
Yes.
And waited on your friends?
Yes.
Okay.
Because they were going to give me a ride home because the car was inoperable.
So how far
and we had to wait for a tow truck.
How far from the scene of the wreck was the pub?
100 feet.
Okay. So when he came to the wreck, he then came to the pub?
Yes.
How did he know you were in the pub?
I have no earthly idea.
Okay. Has he also threatened to damage some of your property?
He has damaged some of my property.
Okay.
He burned a welcome sign that was on the patio. I found the other half of it in the burn barrel. And then there was a sign that said "My Happy Place," and he bent it half in two.
Just so we're clear, you said the wreck was in March. Was that of this year?
Yes, sir.
Okay. Do you recognize those text messages?
I do.
Okay. Tell the court when these are from.
I don't know exactly. I would have to look back on my phone and see
Judge, can she do that?
if I
So she
still
can
have that on my phone.
look back and
Are
see.
you asking for her to be able to consult her phone?
Yes, to refresh her recollection, Judge.
She may refresh her recollection.
I'm not able to find that email.
Well, it wouldn't be email, it'd be a text message.
I mean, text message.
Okay. Read through the messages. Do you recognize this as him talking to you?
Yes, it is, because I was the one that texted him wanting to know if he would put my mail in the mailbox.
Okay. Can you read those messages for the court?
Put my mail in the mailbox. I'll pick it up on my way to the chiropractor at 2:45 to 3:30-ish, or can pick it up on the way to Friendsgiving in Kingston Springs, your choice, which will be a little before 5:30. I have some of your stuff sitting outside the fence. If you pick them up today, I will have some of your clothing sitting out tomorrow. Okay. I'll get the rest when I have a truck. The love seat does not fit in my car, and you need to put the 2 chairs out there that go with it. Hey, Skank, this is my new target for tomorrow morning. It goes to the landfill in the morning. And then I told him that I sent this text to my lawyer. If you destroy my stuff, you're going to pay for it. And then he said, fuck you and your retarded lover, Larry, road whore. I have never had sex with him. I have a contract to pay him back the money I borrowed to get the divorce. And then he tells me I'd rather not
Well,
use.
don't tell us. Just read it. Just read it. No commentary. Just read it.
You are a goddamn liar, you worthless piece of shit. You fucked everything with a hard dick. Then I had ED. You're Bellevue's biggest whore, and he spelled it wrong. You worthless piece of shit. You fucked everything with a hard dick. And then I told him that I was the only person. You are the only what? The only one I fucked this night while you were at work. You got home after late, so I could fuck anyone after 11 or 12:15, and you did. No one can save you now. And I informed him that everything I typed is in blue. You typed that. I guess you forgot what you were going to say. And he says, you're a lying road whore. You licked his dick. How does size asshole taste? Besides, that's the only place his dick has been besides in your mouth. And then he says, I have your magazine basket sitting on the patio with a box of your magazines. If you have any time today to pick it up, pick them up. And have a short talk without losing your temper. Text me back. Sorry, I just saw this. There's no way you can live without your phone for 20 minutes. Did you just get out from under your gang?
Now, Ms. Mitchell, it says there that he's want to have a conversation with you if you could not lose your temper.
That's what it says.
Based on this, does it look like that you're the one with a temper problem?
Not to me.
Okay. Judge, can I mark this as next exhibit?
Exhibit 5.
Now, Ms. Mitchell, in that first text, he was talking about using something for target practice, and there's a mention, you mentioned him destroying your property. Has he destroyed some of your property?
The love seat that I got back, it's burnt on the back, and that's a picture of it.
Okay.
Where it's burned.
What are those other pictures there?
That's a picture of the kids Connect 4.
Okay. Why is that relevant? I don't know anything about Connect 4. So is that damaged or broken somehow?
He left it so the weather could get it. I had it on the other side of the patio, so it was
okay.
Destroyed.
What are the next two pictures of?
Oh, that was the things that he gave me back were kids' toys that my grandkids have outgrown.
Okay. But the only one of any damage is the first picture?
Yes.
Okay. Judge, I'm sorry. Can I tear off those last three? Only admit the first one.
Right. There you go. It'd be 6.
And those text messages that you read, does he text you like that all the time? Just harassing?
He has.
Okay. And are you afraid of him?
I am.
Okay. Are you asking the court to extend this order of protection?
I am, because I don't want him. I mean, Tennessee's the #1 state for women dying, men walking through protection
I'm going to object to her
orders.
testifying as to statistics of domestic violence. I'm going to object to, she's not an expert about domestic violence, and ask that comment be stricken.
And what was your answer? I'm sorry. What were you saying?
That
he asked if you were afraid of it, right?
Yes, I am.
Not sustained anything beyond that.
Are you also asking the court to award you your attorney fees for filing this petition?
Yes,
Okay.
because
Judge,
he
those are-
started this.
Okay. Judge, those are my questions.
No, you may cross-examine.
You had talked about the AirTag and produced a picture. And I want to make sure I understand your testimony. This was in November of 2024. Is that correct?
Correct.
So it was almost 2 years ago.
Yes.
Okay. And then the picture of whose house were you at? The picture from November of 25.
A friend of mine,
Okay, what is your friend's name?
Larry.
What is Larry's?
Larry Minnick.
Larry Mimic.
Minnick.
Minick.
Minnick.
And is that somebody that you're romantically involved with?
No,
Okay, you haven't had any kind of relationship with him?
I did when I was 14.
Okay,
We dated.
okay. But he's recently given you a substantial amount of money, is that correct?
He gave me the money to get the divorce, yes.
How
And
much-
it's a loan.
All right, how much has he given you? Or
Well,
loaned you?
$15,000 for the divorce.
Any other money?
From time to time, yes.
All right. And how much are we talking?
Don't really know. I've not kept a record of it.
Okay. So he's loaning you this money, but you haven't kept up with how much you owe him?
I've kept up with what I owe him.
Okay. So that was November of 25. That was almost 8 or 9 months ago. Is that correct?
It was in February of 2025. I think because that was how I was able to hire the attorney.
Okay, but the picture that you testified to was November of 25. Is that correct?
Correct.
Okay. And then the text that you provided.
It should have been November of 2024.
November of 24?
Yes.
Okay. And the text that you provided, you don't have a date for those?
June 26th.
No, I'm sorry. Let me clarify.
Okay.
The text, these texts that you introduced.
Those texts, I do not have the date because all it says is that it's on I think it said Saturday. Let me look. No, it says Tuesday at 12:31 p.m. And then it doesn't say the date.
All right. It also states in there, you text that you are on your way to a Friendsgiving in Kingston Springs. Is that correct?
True.
So this would have been in around November. Friendsgiving is celebrated in conjunction with Thanksgiving. Is that correct?
Yes.
So this would probably coincide with the other events that happened in November of 2024. Is that correct?
Possibly, but it could have been 2025. I don't know.
Okay.
Because it doesn't say, I don't have a complete timestamp on it.
So you don't know if this was, it was either November of 2024 or November of 2025, but you're not sure which one. Is that correct?
I think it was 2024.
Okay.
But I'm not sure.
Which would go in conjunction with these other complaints that you have. Is that correct?
Well, not if it was 2025. Like I said, I don't really know the timestamp on this one.
Okay. But you complained about the air tag. That was November of 24. You complained about these text messages and then showing up at your friend's house, which was November of 24.
Showing up at the friend's house might have been 2025.
Okay, you just testified it was 2024.
Okay, 2024 then.
Okay. The picture on the couch, you have no idea what happened to the couch, do you?
It's burned. I don't know how he did it.
Okay, you're just assuming that he did that to be malicious. Is that correct?
Well, it wasn't done before I left.
Okay, but you don't know what happened to it.
I do not.
Did you take out an order of protection in November of 2024?
No.
Okay. Did you take out one in November of 2025?
No.
Okay. Did you take one out in March when you had the car accident?
No. I didn't until he wanted me to die.
Okay. And so you took the text, or you took the order of protection. You didn't take it after the incident that you received the text on June 27th. Is that correct?
That was what made me get the order of protection.
But you didn't take it out the next day or the day after that or the day after that, did you?
No, I was working.
You were working. Okay. Is it coincidence that you took the order of protection right after we had mediation that did not settle?
No, that had nothing to do with it.
Okay. You attended the mediation, is that correct?
Yes.
And we had that in Miss Salinas' office.
Yes.
Okay. And did you ever tell the mediator or anyone else that you didn't want to participate in the mediation because you were scared of Mr. Mitchell?
No,
Objection,
because I was
Judge.
already told that we were going to
Objection,
be in
Judge.
separate rooms.
Sorry. There was a confidentiality agreement that's signed regarding the mediation. They're not allowed to
Anything
discuss.
that occurs in mediation is confidential and cannot be introduced in court. So,
And Your Honor, I'm not trying to introduce what happened in mediation. I'm just establishing the fact that she was there and she participated in person in mediation.
and that's been established. I sustain the objection as to anything else.
The mediation was on July 1st, is that correct?
Correct.
Okay. And then the incidents with the text were June 27th, is that correct?
That is correct.
And then when did you take out the order of protection?
I believe it said the 19th it was filed.
So you waited approximately 3 weeks. Just a second, Your Honor. Looks like you signed this either July 8th or July 9th. Does that sound correct?
It does.
Okay.
I
So-
believe it was, I signed it the 8th and it was signed that afternoon and I got the copy the next day because I had to drive back over here to pick it up.
Your Honor, there's a little discrepancy on the order of protection, just for what it's worth. It shows it's filed July 8th. However, her notary signature is July 9th, so I'm not really sure what date it actually was because there's some discrepancy on the date of the petition.
The judge signed it that afternoon and I had to pick it up the next day and that's when the Chancery court woman signed it and gave it to me.
So you took it out several weeks after the incident with the text on June 27th and roughly a week after mediation. Is that correct?
Yes, I believe so.
Okay. That's all I have, Your Honor.
Redirect.
Just briefly, Judge. Ms. Mitchell, after the incident happened on the Thanksgiving or whatever day it was, you were at your friend's house and your husband showed up. Did you recall emailing that to me? That
I
picture?
do. I do.
And Judge, can I pass her the original that has the timestamp on it?
Sure.
Can you read that for the court? What date and time that is? It's in the top left corner.
Yes, it is 11/27/2025.
Okay. So the date that he showed up at your friend's house was this past year, not 24.
Yes,
Okay.
that is correct.
Okay.
I was actually on the telephone with a friend of mine
Okay.
talking to her.
Judge, that's all I have.
Anything further?
Nothing further, Your Honor.
Thank you, ma'am. You may step down and have a seat at the table.
Judge, that's our proof.
All right. Plaintiff has rested their proof on the order of protection. Ms. Snow, do you wish to offer any proof?
Your Honor, I'd like to call Mr. Mitchell.
Right. Mitchell, if you'll stand and raise your right hand, face the clerk to be sworn in.
Mr. Mitchell, you've heard your wife testify, and I'm going to follow up with some questions that she testified to. Have you ever hit your wife?
No,
Okay. And she indicated that you had, but didn't give any details and couldn't remember any dates.
I have never struck my wife.
Have you ever shoved or pushed your wife?
Yes.
Okay, tell me about that.
She was pushing on the gate and she was beating the gate on my arm and she bruised my arm and I got tired of her banging it against my arm and I pushed back and banged on her arm for a little bit.
Okay.
So I just returned what I got.
Have you ever instigated or done anything to push her or shove her in which you were not in a position where you were trying to defend yourself?
No.
Let's talk about some of the things she testified. She had introduced to the court a series of texts and that where you were discussing, she's picking up some things and that she's going to be in Kingston Springs during Friendsgiving. Do you recognize those texts?
Yes, I do.
And did you look at your phone to see when those texts were done?
Yes.
And when were those?
In November, the first text that I on that list was November the 11th. The next text was November the 17th after I found out who wrote her the check for $15,000.
Okay. And that would have been a 2024, is that correct?
25.
25. Okay.
Wait, I'm sorry. Hold on a minute. It's 24. Yes.
Okay. And you were upset, is that correct?
Yes. When I found out that she had been seeing her old boyfriend and her sugar daddy, Larry Minnick, who I graduated with, I was totally shocked.
And do you regret sending some of the verbiage that you sent to her?
Yes.
And did you ever threaten her or did you ever mean any harm by doing that?
I did not. I have never threatened her. I mean, yeah, I said, I hope you die, but hopefully nothing that's caused by violence. You know, I just was hoping she'd have a heart attack or die of guilt or something.
All right. You've been upset during this divorce, is that correct?
Very upset.
Okay.
She's been cheating on me after 51 years of marriage, and according to some of the phone things I found out about David Berry, she was cheating on me before she ever left the house.
So some of this information, you found out about the $15,000 check that Mr. Mimic had given her. We had just gotten that in our discovery. Is that correct?
Yes, ma'am.
Okay. And then you found out about, and I apologize, the other gentleman's name, but we had gotten that when we subpoenaed phone records. Is that correct?
His name and about 3 other guys' names.
Okay. So, and that's when you sent her the text on June 27th. Is that correct?
June 27th started off as not sending bad texts. She sent a box full of flags and things back for my 4th of July decorations, and she had wadded them up, stuck them in there. I texted or called and asked if we had an iron because I couldn't put anything up that looked that bad. And she said, we don't. And then she started an argument, and that argument escalated for the rest of the day.
So was this argument just one-sided on your behalf, or was it also arguments from her?
She started the argument, and she has a real big thing about not answering her phone or stuff when I come. So I cannot tell you exactly how the argument went on the phone, but on the text, it was both sides.
Has she called you names in the past?
Yes. And she's told me she's hoped that I die in the past. I've got a recording of it on my iPad.
Do you have that with you today?
It's right there.
Can you find that fairly quickly?
I'll try. I believe it was April the 11th of 24. I'm sorry, I can't find it right now. I'll hunt for it a while to represent that.
Okay. You believe that was April, you said the 11th of 25?
Of 24. It was before she left because that was about, I'm thinking that was the day where she banged the gate on me and I banged the gate back.
Okay.
Or the day after or something like that.
All right. And these, me, Mr. Mitchell, you provided me a copy of your calls where you called her on the 27th. Is that correct?
Yes.
And we're showing 1, 2, 3, 4, only 5 calls. Is that correct?
Yes.
Okay. And you were only on there for less than 30 seconds on each call. Is that correct?
That's correct.
Okay. And you were upset that day. Is that correct?
Yes.
Okay. And did you leave some voicemails that perhaps you should not have left?
Yes, I did.
Okay. And do you have any intention on harming your wife?
No. Never have. Never harmed her in the past and never planned to harm her.
Okay. And can I make that as an exhibit to your testimony?
Yes.
Mr. Mitchell, I'm going to kind of go back a little bit. Looks like the first thing that Ms. Mitchell complains about you is in November of 24. This is when she claims that there was a tracker on her phone or on her car, and some of these initial texts went out. And were the two of you still married at that time?
In 24. Yes, we're still married today. But
Right.
Yeah, we were married then.
All right. But a divorce complaint for divorce had not been filed by then. Is that
No,
correct?
it didn't get filed. I never received papers till June the 2nd,
Of 2025?
24.
24. Okay. And you're sure it was 24 or not 25?
25.
Okay. So y'all were still together in November of 24. Is that correct?
Yes.
And because I know her attorney is going to ask you, so I'm going to go ahead and ask you, did you put an air tag on your wife's car?
I did in December of 24.
Okay. And then you took it off immediately. Is that correct?
I didn't know an air tag would rat you out. I had no idea that it would tell her that there was one on there. I was trying to find out who she was spending 5-6 hours a day with throughout December. I put it on there because I knew that she was going to take her walk and then she's going to spend some time with somebody.
Okay. But you immediately took it off. Is that correct?
When she confronted me, I waited till she went inside and I took it off.
Okay. And you haven't had an air tag or followed her or done anything since then. Is that correct?
No, I haven't followed her or got an air tag or anything.
Okay.
Oh, let me back up. Yes, I did follow her one time. On June the 1st of this year, me and my grandson were mailing her alimony check. I've got pictures of me putting in the mailbox. We pulled on Highway 70 and somebody in a gray SUV, some woman shot me a bird and my grandson was sitting in the car. I followed the vehicle less than a mile. I got behind it and it was her. She shot us a bird. So she was provoking things that didn't need to be provoked. And as soon as she turned toward Kingston Springs, I went across the railroad tracks, did a U-turn, and came home with my grandson.
Does she provoke you a lot?
Every chance she gets.
Okay.
She knows what buttons to push.
Let's talk about the car accident. How did you find out that your wife had a car accident?
My insurance company informed me.
Okay. And was her vehicle owned? Did y'all have a group policy back in March of this year?
She was on my policy. It was the same policy, yes.
And who was your insurance with?
Safeco.
And how did they notify you?
They text me.
Judge, I
I
object
think it's for the judge.
to this. It's not authenticated. It is not a business record, an authenticated business record, and it's hearsay.
What is it?
Your Honor, is a text that my client can testify that he received from Safeco that there was in a car accident.
Well, I think the text itself is hearsay, but if it's being introduced to show, for a purpose other than admitting its truth, in other words, there's no question about it having been a car accident. So if you're admitting it to show why he took certain action, I'm going to overrule the objection simply because it is clearly hearsay. And I'm allowing it only to allow her to question Mr. Mitchell about why he took certain actions. If it's being introduced for a purpose other than to prove the truth of the matter asserted therein, then I think it would be admissible.
And Judge, the other issue is it doesn't say when he received this text message.
And I think that's the subject of cross-examination. All right.
Mr. Mitchell, is this the text message that you received from Safeco Insurance Company?
Yes, it is.
And is there a date on there?
Yes. The 13th of March.
Okay. And do you recall, does it have a time that you received this text?
I'm going to say the time's between 9 and 9:15.
Okay. There is at the top, it says 10:37. Is that just when you took a screenshot?
That's when that's when I took the screenshot of the text.
All right. But you recall that you received that around 9 to 9:30 p.m. on March the 13th of 26.
Well, it was before, it was between 9 and 9:27.
Okay.
Because at 9:27, made a call.
Okay. All right. And so you received this. Were you concerned about what had happened?
Yes, I didn't know anything about it. I didn't know if she was hurt. I didn't know where the wreck was. I didn't know if she was being transported to a hospital.
And did you attempt to call your wife?
Yes, I attempted to call her at 9:27 after I got this text.
Your Honor, can I make that as an next filed exhibit, please, to his testimony?
You would have had that.
Yes, sir.
Mr. Mitchell, is this a screenshot from your phone where you attempted to call your wife at 9:27 on May the 13th of 2026?
Yes, it is.
And did she answer?
No.
So you did not know at this junction if she's hurt, if she's in the hospital. You don't know anything. Is that correct?
I just know that her vehicle was in a wreck.
Were you concerned about your wife's safety?
Yes.
And Your Honor, if we can make that as the next exhibit to the testimony.
Mark it as the next exhibit in order.
So, Mr. Mitchell, when your wife didn't answer her phone, what did you do then?
I went to the computer and I got on the computer and was able to find a page under Metro Police, under Metro Government. I don't know if it was the police, but it told all the wrecks that was around at the time.
Okay. And your wife was living in Bellevue, is that correct?
Right.
Okay. So were you looking all over Nashville or did you limit your search to Bellevue area?
I limited my search to Bellevue.
And did you find some car accidents in Bellevue?
There was 2 accidents. One was on Old Hickory Boulevard, close to the interstate, and the other was on Sawyer Brown and Todd Priest, right in front of her local bar.
And is that where your wife, to your knowledge, spent quite a bit of time?
I'm sorry.
Does your wife spend a lot of time at that location? To
A
your
whole
knowledge?
lot of time.
Did you then call the Metro Police Department to check on the status to see if they could tell you if your wife was okay?
Yes, I did, and they told me that
Objection, hearsay, Judge.
You can't tell
Objection,
us.
hearsay.
You can't repeat what they told you.
Oh,
state the objection.
Based upon the information that they gave you, did you go out to where you thought the scene of the accident was?
yes. No. I did not at that time. Shortly thereafter, after I was informed that the police had already been there, I got in the vehicle and I decided to go up to the Plantation Pub and see if I could find any witnesses to the wreck.
And this shows that you made the 615-862-8600. Is that the telephone number you called for the Metro Police?
Yes.
And it looks like, according to your screenshot, you did that on March the 13th. And you did one at 10:22 and one at 10:29 p.m. Is that correct?
That's right.
Okay. And can we make a copy of this as an exhibit to your testimony?
Yes.
Your Honor, do you already have his copy? Do you have that? Okay. Again, Mr. Mitchell, were you concerned about your wife's safety?
Yes, but I was not as concerned because I'm not allowed to testify what the police told me, but there was no injuries, is what I was told.
All right. So you just wanted to check to see what the status of the vehicle was. Y'all had a joint policy, is that correct?
Right.
And so her vehicle was insured on your policy.
Yes.
So you then went to Bellevue, is that correct?
Correct.
Did you get there? Were the police still there?
No.
Okay. So the accident had already been cleared?
The accident had been cleared. There was a front end of a Lexus laid in the middle of the roundabout.
And your wife does not drive a Lexus, though, is
No.
that correct? Okay. So you're assuming it was the other vehicle?
Absolutely.
And there was testimony that you went to the pub. Did you tell me why you went to the pub?
I went into the pub and went to the corner where people sat outside. There was nobody outside. The screened-in area, there was a couple sitting there. I asked them had they possibly witnessed the accident, and they did not. I asked another couple right inside the door, and they had not witnessed anything. Then I asked one of the servers if he had seen anything, and he said, "We've been so covered up, I hadn't seen anything."
And then you saw somebody that you mutually knew, is that correct?
No, I went to the door to leave. When I got to the door, I heard a familiar voice way in the distance, and it was her running buddy.
Okay. And did you ever talk to her that night?
No, I did not.
Okay. Did you leave right then?
No, but when I looked over there at the woman speaking very loudly, Chuck, my son's stepfather, was standing at the door. The one she said was her big friend. And he said, "Hey, Keith, how you doing?" And I said, "I'm fine." I said, I was just leaving. He said something about, well, she's over there with Joni.
Judge. Hearsay, Judge.
Sustain the objection.
You can't tell us what he stated to you.
Chuck did not block me from her at all, but I was leaving, and then I saw her and Joni get up, heading toward the door. Before they got to the door, I went outside, stepped off the sidewalk, and turned around and looked at her. And they was all standing inside of the door, and I never spoke a word to her. Didn't know she was there. You know, I can't imagine somebody going into a bar after they just totaled out a couple of vehicles. And I'm sure she had been to the Mexican restaurant. I think that she said they probably had at least 4 margaritas before she left there.
Calls for speculation.
Sustain the objection. You can't hypothesize about what you think she might have done.
So you left and went home, is that correct?
Yes.
Okay. We had mediation on July 1st. Is that correct?
Yes.
Okay. And your wife was there and participated. Is that correct?
Yes.
And you didn't know anything about this order of protection until I called you. Is that correct?
Right.
Y'all share grandchildren together. Is
Yes.
that correct? And is there a birthday party that's coming up?
Both of my grandsons have birthdays next month on the 14th and the 18th.
And do you think she is doing this to keep you from participating in that?
Objection. Calls for speculation.
Sustained.
Tell me why you think she took out the order of protection.
To keep me from my grandson's birthday parties that my daughter said I figured she'd do this.
Okay.
The same objection.
It's hearsay.
Sustained.
All right, Mr. Mitchell, you saw this picture with a couch. Do you recall seeing that this morning?
Yes.
Tell me what happened to the couch.
I know my wife has no idea what refraction is. We have a basketball goal that has a gigantic 1-inch thick plexiglass backboard. Sits at the patio. The couch was sitting under there and it burnt. When I went out and saw that it was burnt, I had no idea how it happened. I moved it. And a few days later, I had another chair sitting there with a cushion and it was burnt. So I started doing some investigations and saw that the refraction from the basketball goal, I went inside and got a thermometer and it was only like 83 degrees outside. And I laid the thermometer on the concrete where the light was being reflected to, and it was 105. And I may have, let me see if I can bring that picture up. That the sun did this damage.
And the couch was outside because she was getting ready to pick it up. Is that correct?
Yes, yes.
And you didn't do anything intentional?
I did not burn the couch. But I have a instant read thermometer that I use when I'm barbecuing. And good grief.
Mr. Mitchell, that's okay. You've testified to that, but you looked at the thermometer and just to see if that's what caused it.
On the day it was 88 degrees, the thermometer read 105 degrees where that light hit it. I got it right here. Can I show this to the judge?
Yes. And then if you...
What caused you to do that?
Pardon?
How did you take a picture of a thermometer on that particular day?
Because I knew I'm trying to prove that she already accused me of this, me burning her couch. I didn't do it.
So
when I saw the light right there, I said, "That's what's done." And so I put the thermometer there, and this day was well, let's see. But where that X crosses, Your Honor, was the hottest spot in the concrete, 105.
You couldn't figure out how it got burned, and you were trying to investigate that, and then you testified that another chair, an outdoor chair that had upholstery, had gotten burned as well. Is that correct?
Right. It burned too. It wasn't quite as bad as the picture, the first one there, but that was earlier in the summer.
Okay.
Or in late summer, in August or something.
Mr. Mitchell, do you have any intent on harming your wife?
No, I do not.
And do you have any issues staying away from your wife?
I just can stay away from her forever.
Okay. You would like to be able to participate in family functions?
I keep my grandchildren every week. I'll have both of them tomorrow.
And do you feel like a lot of these complaints that she's making are things that happened almost 2 years ago?
Yes, Yes, she's been cheating on me for a long time, and that created all the name calling and all the anger.
Do you feel like you have a control and those are no longer an issue with you? Your anger, do you feel like you said that brought a lot of anger? Do you have any anger? Do you feel like that's still an issue, or do you feel like that was something that happened almost 2 years ago?
That happened. Well, I can't be honest and say I'm still not angry. I really don't want to have anything to do with her, but I plan on having everything in the world to do with my grandsons.
All right. That's all I have, Your Honor.
Mr. Williams, you may cross-examine.
Thank you, Judge. Mr. Mitchell, you keep saying that your wife's had an affair. She's adamantly denied she's ever had an affair. Has she not?
Yes, she's always denied it.
Okay. And you admit now in court that you stalked her. You placed an air tag on her car, correct?
Right. And I had plenty of good reasons. I have many days in December where she would use her vaginal lubricant and go out and be gone 5.5 to 6 hours every day she left.
Okay. Are you aware that it is against the law to track someone without their consent?
I had no idea.
Okay. And after she confronted you, then you went and took it off.
Yes.
So if she hadn't confronted you, you would have continued to track her, correct?
I wanted to find out who she was with so I could.
Is that a yes? You would have continued to track her if she had not confronted you?
Yes.
Okay. And you came to this person's house on November of 25, correct?
November 27th of 25, Thanksgiving Day.
That's you in the car.
That's me in the car.
Taking pictures of her vehicle, correct?
Right.
Okay. How did you know she was going to be there?
I didn't.
So you just showed up somewhere that you thought she was going to be?
It's like this. I was cooking supper for my children for Thanksgiving dinner. I needed something. I ran to Kroger's. Kroger's was closed. I just started to leave Kroger's, and I thought, I bet she's over with her sugar daddy's house right now, which is Larry Minnick, the one who gave her the money to pay you, the one who's given her $40,000.
This person's house. This is his house, correct?
That's his house.
You pulled into his driveway, into his backyard, correct?
Yes.
Okay.
That's the only way I could prove it's her vehicle. I got a picture of her vehicle through the woods, but I could not prove that it was the same vehicle.
You got a picture of her vehicle through the woods?
I was on the road behind the house. So I had to drive in the driveway to take the picture to prove it was her.
Did you have permission from the owner to be on his property?
I wouldn't ask him permission for anything, no.
Okay. So you're just going to trespass to follow your wife?
What do you mean trespass? People come to your house, knock on the door all the time.
Okay. You think it's appropriate for you to pull into someone's backyard and start
Yes,
taking pictures?
to prove that my wife is in there having sex with Larry Minnick. Yes.
You have absolutely no proof that she was having sex with anyone, do you, sir?
Well, I think I do.
Do you have?
She has all the actions of a cheating wife.
Okay, Mr. Mitchell, you sound very angry. Would you agree that you're pretty angry?
Yes.
Okay, and do you understand how, when you take your anger and you accompany that with the words "I hope you die," you understand how that could put your wife in fear?
No, it doesn't put her in fear because she said it to me.
Okay. And where'd you get the AirTag from that you placed in her vehicle?
Best Buys.
I'm sorry?
Best Buys.
Okay. Have you tracked her prior to that?
Never.
Okay. Did you have a tracker on her vehicle this year when she had the car wreck?
Absolutely not.
Well,
I have never touched her vehicle.
Okay. You testified earlier that it was the bar she hangs out at all the time. How do you know she hangs out at that bar all the time?
I've got friends that tell me.
Okay. So you and other people are following her as well.
I do what?
You have other people that are telling you her whereabouts?
Everybody knows her whereabouts. She runs with a group of loudmouth women.
Okay. And you admit that you showed up to that wreck and you said that you didn't know she was okay. Is that what I heard you say?
No. I showed up to the wreck to try to find if somebody saw what happened.
Okay, so you didn't care about her well-being.
Yes, I did.
Okay, did you ever ask her if she was okay?
She wouldn't answer the phone. How can I ask her?
Well, you were at the restaurant where she was at. You saw her. Did you ask her if she was okay?
I stayed away from her because she's been claiming I've been following her for years. Not for years, for a year. And my daughter was expecting her to do this at this time, so I wouldn't get to come to the birthday parties.
Your attorney gave you an exhibit number 7, where you're saying that is it your testimony that this is all the times that you called her this night?
I don't know if it is or not. It's the same number of calls that I looked off the exhibit.
Well, your call log doesn't start till 8:09. On your wife's call log, there were 6 different calls prior to this, all in the same hour.
Okay, I did not see that.
Okay. So you called her 9 times in less than an hour.
Okay.
Do you think that's harassing?
No.
You don't think calling someone a whore and a slut every voicemail is harassing?
I guess it could be considered.
Okay.
But if you deserve it, you need to be called that.
Okay. You get mad when she doesn't answer the phone when you call. Isn't that true?
Okay.
Is that true?
Yeah.
Okay. You want to control her, and when she doesn't take your call, you get angry.
No.
And accused her of having sex with I think you said you just got out from under a gang is what you said. What did you mean by that?
Gangbang.
Okay. So that's what you say. That's what you assume she's doing if she doesn't answer your call.
No.
Well, that's what you said.
Well, I might have said at that time.
Okay. On Exhibit 5 here, I want to know, what did you mean when you told her, "Hey, Skank, this is my new target for tomorrow morning"? What did you mean by that?
I had a piece of her china that she has now set out and took a picture after I found out who she was screwing.
And so you're threatening to destroy her china.
I was after I found out who gave her $40,000, yes.
Okay. So you were threatening to damage some of her property.
I did make that threat.
Okay.
But I never damaged anything.
You said earlier that there was an incident where she was pushed on a gate and you pushed her back. Remember that?
Yes.
Did you cause her arm to bleed?
She caused my arms to bleed.
Is this a picture of her arm bleeding after that incident? Judge, may I approach?
You may.
Is this a picture of your wife's arm bleeding the day of the incident?
Probably not. She probably went in there and made it look worse because I don't remember anything like that.
Okay. So when you said you haven't hit her, or you haven't harmed her, that wasn't actually correct, was it?
I didn't harm her. I just gave her back the gate she gave me.
I got a question for you. Why? You said earlier your attorney asked you if you had stalked her, and you said that you admitted that you turned around and followed her. What were you going to do with her when you caught her?
I did catch her, but I turned around and left. I wanted to make sure who it was.
Okay, well, you saw her when she passed. You were glaring at her.
She's got smoked glass in her vehicle. I was there looking at the traffic go by, and all of a sudden I looked up and somebody shot me a bird.
And you did a U-turn and went after her.
I didn't do a U-turn. I just pulled out behind her because I was going that way anyway. I didn't pull out behind her. I pulled out behind the line of traffic that was behind her, and I had to wait to get to the turning lane to pull over to see if it was her.
Mr. Mitchell, how many guns do you own?
10.
Okay. Where are those guns now?
They're in my gun safe.
Are all of them in your gun safe?
All except the ones I gave away to my family.
Just those are my questions.
Ms. Nell?
Mr. Mitchell, you didn't know that was your wife in the vehicle because she had a new vehicle. Is that correct?
I knew that she had a new vehicle, and I knew it was the same color as the one that came by, but I did not know it was my wife.
Okay. You just didn't know if it was some random person that shot you a bird.
Right.
Because she had totaled her vehicle and had a new vehicle, and you didn't really know what it was. Is that correct? Or you had a general idea, but you didn't know if that was.
No, I knew it was her vehicle because we both have been to ball games together. She sits at the stands, I sit at the end of the dugout, so we stay away from each other. I do
Okay.
not approach her at any of the ball games, and I mean, I have been as close to her as me to the judge at one of the ball games, just, you know, at the end of the ball game when we're saying goodbye to her grandson. But I've never approached her.
Were you injured at the incident with the gate at the house?
Yes, ma'am, I sure was.
Okay. Tell me about the injuries you received.
Bruises and blood.
Okay. And you have pictures of those. Is that correct?
I think I gave you pictures and they're in the main files.
Okay. All right. But you have those. Is that
Yes.
correct? Okay. And you understand from today and from our conversations that you cannot put an air tag or anything on, and you're not planning on doing that. And you only did it once. It was during your marriage. You had not separated. The divorce had not been filed, and you haven't done anything since then. Is that correct?
I haven't put an air tag on anything since then. Since that was December of 24.
Okay. No, divorce wasn't filed till May of the following year. Is that correct?
Right.
That's all I have, Your Honor.
Anything further, Mr. Williams?
No,
Step down. Have a seat by your lawyer. You have any other proof, Ms. Nell?
No, Your Honor.
You wish to put on rebuttal proof?
No, Judge. You wish to have argument, or
I will hear you an argument.
All right. Judge, this behavior is escalating. It's getting worse, and we now know that Mr. Mitchell admits to tracking his wife back in December with an air tag. He testified by his own testimony that he would not have taken it off if she hadn't confronted him about it. I don't know what the distinction is, whether they're still married or not, because it doesn't matter. The statute doesn't really matter if you are tracking your spouse or your girlfriend. I mean, it's illegal to track a third party without their consent. He has stalked her. He admitted now that he's taken pictures of her at someone else's house through the woods and then goes on that person's property to take a better picture. He admits that he's angry with her. He thinks she deserves this behavior that he is putting towards her, and he doesn't see a problem with it. He even said, if you act this way, then you deserve to get called these things. My client has a serious concern. It is harassing behavior. It is annoying, but it's also threatening. When you tell someone, "I hope you die," after calling them 9 times in less than an hour, and with everything they've been through, I think it amounts to that she needs an order of protection. And an order of protection is only good as a piece of paper, but hopefully he'll get the hint, stay away from it. Judge would also ask to be awarded attorney fees for this.
No.
Your Honor, there's a huge burden on an order of protection. The behavior that the alleged victim alleges, has to be where they're in imminent harm. Most of the circumstances.
Does it say that in the statute?
It says, well,
But not the statute that I've been reading this morning. It only requires that abuse be inflicting or attempting to inflict physical injury on an adult or minor by other than accidental means, placing an adult or minor in fear of or in physical harm or physical restraint, causing malicious damage to the personal property of the abused party, or intentionally engaging in behavior that amounts to financial abuse. It also goes on to identify that victims of domestic abuse also include people who have been stalked. So
And
just
you're
wanted to make clear that I've been reading the statute during this hearing, so I'm pretty well familiar that it doesn't require the type of immediacy and seriousness as you were saying. But I've interrupted you, so please continue.
Well, Your Honor, I think it refers to the definitions in 3917-315 as it deals with stalking and harassment. And it says that it would cause a reasonable person to be frightened, intimidated, molested, terrorized. Your Honor, a lot of the behavior of Mr. Mitchell occurred before the divorce complaint was even filed. She never filed an order of protection then. She didn't file one. She didn't file one in November of 24. She didn't file one in November of 25. She didn't even file one immediately after the contact on June the 27th. She waited 2 or 3 weeks, and she did it right after mediation, and it wasn't successful. Your Honor, I don't feel like she feels threatened. I don't think that Mr. Mitchell's conduct goes to that extent. Has he been upset? Yes. Is he the first person that has called his spouse a name during the pendency of a divorce? No, he certainly isn't. As you know, this court's heard lots of testimony and in divorce cases, and it's pretty common that people call each other names when they're getting a divorce. I don't think that in and of itself is enough to issue an order of protection. You know, Your Honor, my biggest concern with this is that the parties will not be able to participate in family functions. He has no desire to be around his wife, but doesn't want to be limited in these type of functions. Your Honor, I would respectfully request that it be dismissed. This divorce has been pending for a long time, and she's never done anything. So I feel like it's being done as a strategy to kind of get back at Mr. Mitchell or to accomplish some end result to keep him from having contact with his the party's family. And I would respectfully request that it be dismissed, and I would request that I be awarded my attorney fees.
In this day and age, people oftentimes say things without relevance to whether or not they're true. But it's always been this court's belief that words matter. Words carry significance. That's why you can have an assault against someone even though there's no physical contact, because your words could place someone in fear of imminent injury and so forth, just simply in the context and under the words that are uttered. So I've been doing this a long time, probably longer than the 2 lawyers that are involved in this case. I've been judge now. This is my 12th year. I have represented a lot of people. I've represented a lot of people who are charged with abusing their spouse and so forth. I've heard a lot of cases, as Ms. Noe points out, and she's right. It's not the only case that we hear people calling names. But in all of my years, I can say that I don't think I've heard anything quite as vile and offensive as this list of phone messages that Mr. Mitchell inflicted upon Mrs. Mitchell. Sure, he may think she's having an affair, then that's fine. File for a divorce yourself, get a lawyer, take it to court. But calling someone these vile and offensive names repeatedly, calling her over and over and over again, and then at the end of that saying, I hope you die, coupled with the fact that she was aware that in the past you had placed a tracking device on her car. And by the way, 3913-606 of the Tennessee Code says electronic tracking of a motor vehicle, except as provided in subsection B, which has to do with law enforcement. It is an offense for a person to knowingly install, conceal, or otherwise place an electronic device, tracking device, in or on a motor vehicle without the consent of all the owners of the vehicle for the purposes of monitoring the following an occupant or the occupants of the vehicle. That's a Class A misdemeanor. Now, the statute's already run on that since it was apparently more than a year ago, but that's clearly a situation where you committed a crime against your wife. And then, and she knows that. She knows that you had done that. And then you have these other situations where you are, following her, and clearly that's been within recent times. If you don't want to be married to someone that you think is running around on you, that's fine. We can deal with that. But that does not mean that you have, even if she's your wife, that you have the right to use the type of language and to place her in fear of that. And I think it is a reasonable fear that she has when the man that she's been married to for 53 years, who has tracked her, is following her, and then on June 27th sends her a series of text messages that accuses her of everything under the sun, some of the most offensive things that you can imagine. And then at the end of that says, I hope you die. I can understand why she would be in fear for her safety. I think a reasonable person would. So it is this court's opinion that stalking of her, as has been proven by your own testimony, and the most significant thing that you said today, the most significant thing I heard was when Mr. Williams was cross-examining you, and he said, if she hadn't confronted you, you would have continued to have tracked her and stalked her. And you said, yes, he would have. Well, that tells me that there is a need for a protective order to prevent this stalking from taking place. Now, I do find that there is a basis for finding that an order of protection should be extended. However, the order of protection does also contain certain abilities of the court to allow for certain contact between the people, sometimes called social contact. And for that reason, I do not intend for this order of protection to prevent Mr. Mitchell from having an opportunity to attend his grandson's birthday party. They will have no direct physical contact with each other. They will have they won't speak to each other, and this goes to her too. I don't think she wants to speak to him, but he should be allowed to be there. This will be a social contact that allows him to be at family functions, so long as he does not have any direct physical contact with Mrs. Mitchell. Now, he told me you want to see your grandchildren, that that's what you want. I'm going to give you that right. I have grandchildren of my own. I don't want to ever be prevented from being able to see them. But if you violate this order, you're not going to get to see your grandchildren because you're going to be in jail. I don't want to do that. I don't want to put you there, and you don't want to be there. So make sure you understand. This may have been a temper tantrum that you threw that day, but as I've said, words matter. And in this case, I think the words that you used on the June 27th phone messages repeatedly are so severe that, coupled with the previous AirTag stalking and following that, the stalking that occurred in November of 2025, all of which serves as a basis for this entry of this order. Mr. Williams will submit his application for attorney's fees, and I will consider that as a part of the record.
Judge, I just submitted order with a blank in there and my attorney fee affidavit.
That would be fine.
Thank you, Judge.
That concludes this hearing. I hope that the two of you, at some point, the two of you had some feelings for each other. I know you've been married since you were 17. Is that right? So you've been together a long time, and I know you had feelings for one another. Whatever. It's easy to have harsh feelings towards somebody when you feel like that they're throwing away your marriage. But you don't want to be married to somebody that you don't trust and that has, in your opinion, been messing around on you. She doesn't want to be married to you anymore. So you two need to solve your problems, just get away from each other. And maybe you can, in the future, have some sort of a relationship where you can at least tolerate each other enough to be around your grandchildren at some public events. All right. There will be no messages of any kind interchange. He will not text her. Any communication that you need to have with her, go through your lawyer. That will mean no direct or indirect. You can't send her a message by one of the other family members as well. Anything else that I've not touched on? All right, then that concludes this case. We will adjourn for lunch until 1:15.
All rise. Board is adjourned for lunch. Back at 1:15. Just I mean, I don't know.
When we reserve? What time? What time will you come back?
1:15.
All right. I just want to make sure. I've been known to screw up. I know you find it hard to believe.
Absolutely.
Thanks a lot.
Just hang on to it. Don't let it go.
I did that early, not realizing.
It's loud when you let it go.
I thought I was going to get arrested, thrown in jail. I tell you, you'd have to carry me. I would have fainted. So I'm glad it didn't happen.
The people that built this thing didn't consult the people that had to use it.
Typical. Typical. Take care, my friend.
Yes, sir. I'll take you lunch.
And he's actually supposed to be served with. Can you just email it to me once he signs it? Because I was asking them, like, only there's a specific form order that y'all have extended LP.
Yeah, there should be one. There should be. Okay. I thought I saw one in there, but maybe not. Should be. If you'll just get a form order, we can fill that out. I'll have some way to fill it out if you want to do that. So what do we have left? Let's wait for some brown. These two are the last two.
Yes. Thank you.
Appreciate it.
thing right there is gonna end up hitting and chipping off the top of that.
Yeah, I was just trying to figure out what's the problem.
They put spring hinges on it. These things have got a weight load on them.
Oh,
So when you look right here, it's sweet. It's designed to do that. It's not a malfunction. It's just these springs, they have a weight load on them.
okay.
And see, it's just a dual-sided deal, right?
Yeah.
It's meant to go either way, but they're gonna have to do two things. I think they're gonna have to put a different weight load on here, remove this cap, or they'll have to cut and trim that down. It's just several times a day where when it hits, it will break that composite.
Litigants, when parties, when they come up, they don't know.
No.
They're gonna just let us
Anybody that's got a half a brain can see it when they're sitting out here, but I'm surprised they don't have a half a brain.
There's an abundance.
Oh. I started doing it late 2024 because we did a few projects, and then Walmart shuts off for that part of the year, and then we had to keep certain people employed all throughout the whole winter, and because then we were being promised that Walmart was going to schedule back up, which they did, and so I'm still all through March, April, May, June, I'm recovering from free payroll. I'm still the whole time taking right off the top of each job.
These chairs are so much. That's great. That's cool.
And you kept on seeing those places where he was at.
So it's going to take
that was just all time, just
swallow and talk.
Not lose out while you're.
That's for sure. Go civil.
They're different than like if you take the money out of your account. I'm sorry, but this afternoon ain't gonna be this entertaining. I don't know.
Me and this fella right here, I'm sitting in the back, and I started to laugh, and I was like, "Oh shit, I gotta hold it together." And I look up, and his belly's bouncing.
I know, hell, I looked over at it and I thought, I can't look at it. If I look at it, I laugh.
Oh Lord, I didn't eye shot of the judge. I just tried to keep my laugh.
He was the best witness she had.
Oh God!
Oh yeah,
he buried himself.
Yeah. When he testified for his lawyer, I thought, boy, you just opened the gate.
Yeah, she might not should have called you, but you never know. Yeah, I mean, you're
Oh, I'm sure.
No, you know it. He had his life. She didn't have to.
Stroke out there.
Where'd you eat?
Went down Mickey D's, worst place in
He
America.
was his own
I found a little spot down the road. Most of them has gyros. I'm gonna tell you something, surprisingly, pretty dang good gyros. Yeah.
Doesn't look like much from the outside, but it's.
What do you think else open?
McDonald's.
Yeah.
You're right. There was nothing else open. I should agree.
Something went wrong. I mean, I didn't vote for mine. You know?
She was jumping that down. Somebody's getting the phone call.
Oh, you know.
She was taking that name down, spelling.
That's what I thought.
She was making the funniest face.
Yeah, he gets
Well, she put her eyes was rolling.
I had a side
testifying.
Yeah. Well, you know they've married 53 years.
Yeah.
She ain't far from it. You know what I mean?
Yeah.
She gotta be pretty much like you.
You don't want to take that mediation, or you did mediate. Oh.
She just got a couple of brain cells splits her. Not say nothing.
I have to say, I've been doing this a long time, but that's the first time I've ever heard naturally lubricant used.
Was it as exciting as
Very awesome. We're starting at the vote.
Oh, I'm telling.
Yeah, I mean, I did.
Yeah, absolutely. After that, from the moment you figure the attorney will go, look, y'all can't force my client to stay in. He ain't saying nothing.
He'd been a lot better off. He never took a stand. Yeah.
Not even showed up.
But I guarantee you, he was insistent to his lawyer that he testify.
Yeah.
Tell his story. Tell his side of the story. Yeah.
Hey, when he was over there recording, I seen him record with his cell phone. He's over there recording the whole time. That's the first thing he's gonna do to get himself in trouble. He's gonna share that recording to all the people around. That probably interferes with the order of protection.
Yeah. And then he said, well, I couldn't get a good picture in the woods. I'm thinking, set that hook.
The judge goes out, wait, she was in the woods. This guy had full army fatigue suit on. Yeah. He said, you pulled in the driveway and you got all the way in the back of the yard. He goes, I couldn't get a good picture when I was in the woods.
Then when he was talking about that magnifying glass burning that couch, I'm thinking, well, where'd you come up with that?
Refraction.
And he said,
Yeah.
I put another chair there and it burned my chair. It's a good chair. And I was like, well, why'd you put it there?
Then the judge said, why did you take that picture? I'm thinking, yeah, he called it too.
Maybe it just actually feels nice.
You break it like it runs.
Okay, well, he got COVID here. Oh, I thought there were COVID.
Ropes got the hood on it, the arms.
Yeah, complete wrap you up.
Yeah.
Hey, y'all need refrigerators back there. You can hang beef in this court.
Yeah.
Especially if you're sitting where you're sitting back there and we're sitting right here. It just
You
comes.
got one there and one there.
Hey, eventually I got back behind this wall right here. It was only saving grace I had. I was freezing.
Yeah. And it's not bad if you're over there.
When did this new part open up?
When what?
This new part of the courthouse open up? It just opened.
We
Last couple of weeks.
they moved the inmates over here June the 5th.
The inmates underneath us.
Underneath and back there.
Yeah. They got some things they got to work out.
Well, see, if we need an inmate for court, we can, behind that door right there is lock-up cells. They can bring them up there, and we can bring them from there in the courtroom.
Yeah.
And plus, there's 2 rooms over there for attorney-client. They can put him in there and tell the attorney which one he's in.
These courtrooms are a lot more current than the previous ones that have been there since probably the 70s.
Yeah, but they're small.
These,
They ain't near as big as our other 2.
Are the other 2 still in use?
Huh?
Are the others still in use? The other one's still in use?
Yeah.
I went to call court.
Yeah, we had civil court over there in General Sessions.
All over the place.
so they're larger than this. I thought they were small.
Yeah. To me, it was larger.
They're larger than this one. The other courtrooms.
Oh, yeah.
I thought they were small. I thought they were small.
Yeah. And we'll have juvenile court over there tomorrow, and we'll have General Sessions over there Wednesday. Not unless something changes, who knows? It depends on the judge and where they want to have it. Now, when everybody's talking in the microphone, you can hear good. But if the attorney just stands up and don't get close to the microphone, because the fans, the judge can't hear what they're saying.
Yeah. You walk out in that hallway, the air ducts out there. I've been in construction a long time in my life. The amount of noise that those air ducts are putting out, it's not supposed to be that way.
Yeah.
These right here are much louder than an inner office is supposed to be.
Well, and they're working on it because the judges are talking about it's too loud. But somebody, and I don't know who controls it, but it's got to be on a central system somewhere controlled by computers, because it ain't controlled by that thermostat over there.
No, it's not.
We tried that, didn't we, Ron?
I think it's just a dumb mistake.
That
Just shows temperature.
It shows temperature. That's all it does.
You would think that I would think that whoever the design engineer that's involved in this place would have considered that greatly in this.
66.
Well,
It's up 60.
I don't know what they done, but there's a lot of things that it's not practical. They didn't talk to who has to use them. You know, like one of the biggest gripes is
Oh, that's great.
the witness stands over there.
Yeah.
The attorney sitting here can't see the witness. You know.
Oh yeah.
See what I'm saying? Yep. And it's right the opposite in the other courtroom next door. The witness stand is on this end, but the attorney over there can't see the witness stand either. They're identical. They're just backed around a little bit.
You all were talking about that kind of during the proceedings. I was thinking to myself, I said, as much money as it probably took to construct this, you figure they would have brought in design that specialized in courtrooms.
The other courtroom doesn't have a jury box because this is where criminal court happens. The other one is like general sessions, you know, stuff below here.
All these courts around Middle Tennessee are just very busy. All of them. What?
Don't have no judges.
I'm doing that. No other place.
Okay.
All rise. Court is back in session. You may proceed.
You cold? I may need to come over and see. Are you unmuted? What now? Yes, as far as I know. I think we had. Did we ever get the inmate up that we were supposed to be doing? He had been released. That's right. Okay. Thank you. All right. Well, let's take up what we have left. National Electrical Company versus Sean Christopher Gary. This gentleman, I'm wanting to go ahead and try to take care of it, but one of the things that I'm looking at is a Rule 60 motion that's been filed, and it alleges that you're asking to set aside a default judgment that was entered in March. Is that correct?
Yes, sir.
That was before Judge Turnbow.
Yes, Your Honor.
It's always been my practice since I've been on the bench that if there's a Rule 60 motion to set aside a judgment that some other judge has entered, that judge needs to be the one to hear it. Any reason why Judge Turnbow could not hear your motion for Rule 60 relief?
No, Your Honor. I represent Mr. Geary and all about electrical. And there's no reason that we would oppose Judge Turnbow hearing it.
Well, Your Honor, I'm Greg Oakley for the plaintiff, Your Honor.
I'll concede that he is Greg Oakley, and I've known him for many years. We've had cases together in the past. I'm sorry, Your Honor, I couldn't help it.
And Your Honor, I don't have an objection to Judge Turnbow hearing the motion, although it's really a simple motion that I think that Your Honor could handle, that we could argue in 10 minutes. There's not a whole lot of factual dispute. And I mean, if the court is prepared to go forward with the other motions, the motion for charging order and the motion for contempt, then I would prefer that the court hear the Rule 60 motion today so that we can get it over with.
Well, if I'm not going to hear your motion for Rule 60, I'm not going to hear any of the others either. I think it would be more appropriate to have the other judge hear it. But
Your Honor, can I be heard on that for a second?
Yeah.
So an issue that we have with a further delay with respect to especially the motion for the charging order, is that the subject of the charging order motion, which by the way has not filed a response to the motion, nor did it file a response to the motion for contempt. It's our understanding that the judgment debtor, Mr. Geary, formed this new company called TNT Electrical that does the exact same thing that the defendant judgment creditor All About Electrical company was doing. Namely, it does electrical contracting work for this company called Divisions Inc. or Divisions Maintenance Group. They do electrical work at Sam's Clubs and Walmart and Costco's, places like that all over the country. And our information is that TNT is doing significant business with DMG, for which they're going to be paid a substantial amount of money. And I filed this motion for a charging order back in early June because we would like to get a charging order in place so that all that money doesn't flow through to TNT and then disappear. This defendant, Mr. Geary, somehow disposed of $1.4 million in a 6-month period, $500,000 in a 3-month period. And we're just afraid that if this money comes in, it's going to go away and we're not going to be able to attach to it. And there's really no, I mean, a response has been filed by the defendants to the charging order motion, but there's really no defense to it. There's a judgment in place, and Mr. Geary does not deny that he is the owner of the LLC called TNT or TNT Electrical LLC. And so just purely as a matter of law under the charging order statute, we're entitled to a charging order. Now, we've asked for some reporting and for the appointment of a receiver. We can wait on that until Judge Turnbull can hear it, but we would like a charging order to be entered today, or the court to grant one and have me submit an order, because otherwise this money, substantial amount of money that we could use to pay down the judgment, is going to go away. We won't be able to get it back.
All right, Your Honor, we did file a response, and our response was talking about the extraordinary relief that is requested. And this is if the Rule 6002 motion is granted, it will be moved. They have asked for interest on the judgment, and they can always do post judgment discovery. They can do all kinds of things. A short delay for the original for Judge Turnbow, who heard it, is not going to be prejudicial to these folks, and therefore I think it best that one judge, the judge who's heard all this, Judge Turnbow, to hear and decide. And I'd also say, well, Mr. Oakley, who is a friend of mine, allowed me to file this Rule 60 motion last week. He did file a response on Saturday. On this weekend, I was 200 plus miles away for my mother's 100th birthday. I didn't get a chance to look at it until late yesterday afternoon or evening, and I haven't had a chance to talk to my client. So I think that it would be best just to hold all this off until Judge Turnbow's next date, and no matter what, we will be there.
Your Honor, if I can just briefly speak. I don't know if the court has read the Rule 60 motion or had the opportunity to it, but there's no.
I haven't had the opportunity.
Okay.
Not only was he away from this area, I was in another county this last week and was not able to review the file at all. So I'm going to want to review this file before I'm going to read the motion for Rule 60 relief. I'll probably communicate with Judge Turnbow here in just a minute and see whether or not he has any objection to me hearing it. And if he does think, as I do, that it would be more appropriate for him, I will determine whether or not that can be done quickly. If it can't be done quickly, then I'll probably hear this Rule 60 motion.
So, we also would not mind, I think I can speak to Mr. Oakley, going to wherever Judge Turnbow is and having it heard there in order to get it expedited.
Let me step off. I need to check to see, when is Judge Turnbow back here? He was here in March, so that's not going to be. So he's not here till October. But I know he will be in other counties, and like me, I think Judge Turnbow was willing to set some other matters. So let's see what I can find out, and I'll come back in just a few minutes. So.
All right. Court, stand for break recess.
No, I'm fine. Okay.
All right. He'd stand you up. I'd help him. I was in court one time when this lawyer been over. He couldn't strike one. That's why.
No.
For the record, I got Mr. Oakley's response on Saturday while I was in Memphis celebrating my mother's 100th birthday. I didn't get a chance to look at it until late yesterday afternoon or early evening, and I've been unable to contact my client about it. Having said that, I'm prepared to go forward. There is no doubt that a default judgment was entered. There is no doubt that my client did not respond in time. According to his affidavit, he didn't have the funds to do it. Now, there's a counter affidavit that was filed. I haven't had a chance to talk to my client about. But, Your Honor, Rule 6002 exists for a reason. It's not just out there in the blue. And it allows for relief from the judgment. And we're relying upon 6002 2 and 5. That's exceptional circumstances. My client has filed an affidavit saying he didn't have the funds. He talked to many lawyers. I believe he said he talked to about 20 law firms. He couldn't find a lawyer. This is a fairly complicated case. He found me, and I have filed this Rule 6002 motion. The motion for default is at almost $1.1 million right now. It's probably a little more than that with interest. And so this is not a trivial matter. He has filed a proposed answer and counterclaim, and he's making allegations against the National Electric Company and its controlling person. So the question becomes, is this an exceptional circumstances? Is this an exceptional circumstance? We understand that Rule 6002 motions are not granted easily, but this is a case where a $1+ million judgment has been entered. And as this court well knows, defaults are not favored in Tennessee. They've never been favored in Tennessee. I've been doing it for 48 years, and I've had many a default turned over. The default was entered in March of this year, so we're talking about a break of a few months. We are prepared to expedite discovery and get this to a very quick hearing, so that it can be decided on the merits, which a case of this magnitude should be. I saw Mr. Oakley's response late afternoon, or actually evening or night yesterday, and I've tried to contact my client, couldn't get a hold of him. But I would like to respond to it. One side will make allegations, the other side gets a chance to respond. If someone doesn't have the money and doesn't know how to refer to it, and has made good efforts to try to find a lawyer, he says that over 20 law firms or lawyers he tried to contact in his affidavit. He couldn't find one who would take it. If you can't pay a lawyer on a complicated case, or a lot of cases, lawyers simply not going to show up. This would be a grave injustice to him. He also has some claims in tort and conversion against the plaintiff, and those are set out in the counterclaim as well, Your Honor. They're also mentioned as defenses, recoupment, and set-off. So the question here, Your Honor, is real simple. Should we allow this case to be heard on the merits and decided? And I assure you we will expedite it, and I would work with Mr. Oakley to expedite it and get it heard and as quickly as possible. He and I have worked in the past, and I think we have a good working relationship. But be that as it may, I'm asking the court to set it aside and to go from there. I didn't have a chance to respond to the Saturday filing because I was out of town at my mom's 100th birthday. It only happens once. So I appreciate it. Thank you very much.
Mr. Oakley?
Yes, Your Honor. Again, I'm Greg Oakley for the plaintiff, and I have here with me Mr. Ryan Carney, who's the president of the plaintiff. And just to address the whole Saturday filing, this motion was filed on Tuesday afternoon, which is really not even 5 days from today, which is the minimum time to file a motion. And I had depositions all day Wednesday and Thursday, so I did my best to put together a response on Friday. I had some technical issues that kept me from filing it on Friday afternoon, so I filed it on Saturday, but that was just 3 days after the motion was filed. And Mr. Kraft has glossed over what his motion actually stands for, or what the reason that his clients claim that they're entitled to Rule 60.02 relief. What they claim is that.
Let me just say this: I did read through the motions, and I had not read your response because I wasn't aware that you had filed it. But in my short recess, I did read through his motion and what he claims.
Right.
So go ahead.
Okay. So, and the motion was filed pursuant only to 60.02 for excusable neglect, not 60.05 or 60.025, excuse me. In any event, since Your Honor has read the motion, you understand that the claim is my client said some bad things about Mr. Gary, and therefore their biggest client stopped doing business with him, and he didn't have any money because of that. But someone who is requesting Rule 60 relief has to substantiate this request with clear and convincing evidence. Right? The evidence that has been submitted by the defendants is the affidavit of Mr. Gary, who says in the most vague possible way that sometime in the summer of 2025, my client said bad things about him to a third party, causing this third party to stop doing business with Mr. Gary. But there's nothing in the affidavit to demonstrate that Mr. Gary was present in this conversation, that it was recorded. How does Mr. Gary know what my client told some third party? It's clearly inadmissible evidence under Rule 602 because Mr. Gary lacked personal knowledge. It's also hearsay, Your Honor. I mean, the only way that Mr. Gary could possibly know what two other people said is if somebody else told him. That person would be a declarant, which makes it hearsay. So it's inadmissible under Rule 602. It's inadmissible under Rule 802, and it's completely uncorroborated and unreliable, and frankly, Your Honor, not worth anything. So just from the outset, the burden of establishing what they need to establish with clear and convincing evidence has not remotely been met, Your Honor. Furthermore, it's also not true. And this may be kind of hard to tell from my response because I had some issues with the exhibits, but I attached as exhibits to my response several months worth of bank statements of the defendant All About Electrical Inc. And so the reason this case exists is because my client, NEC, National Electrical Company, had an arrangement with AAE, All About Electrical, which is owned by Mr. Gary, under which NEC was providing the labor and materials for these electrical projects. AAE, Mr. Gary was in theory supposed to be supervising the projects, but my client was furnishing all the labor, all the materials. The contract was between the owner, DMG, and AAE, Mr. Gary's company. The deal was that Mr. Gary's company, when it got paid by DMG, was supposed to give that money to NEC, which it would then use to pay the expenses, the labor, and the materials. And then NEC and AAE would split the profits 50-50. Mr. Gary did that a little bit, but especially towards the end, he completely stopped doing that, kept all the money for himself. And I attached, like I said, exhibits as the All About Electrical bank statements as exhibits to the response. And they established that, so the complaint was filed and Mr. Gary was served on October 15, 2025. In the 3 months leading up to that filing and service of the complaint, All About Electrical Inc. deposited $700 and something thousand into its bank account. Almost all of that was payments from DMG. Now they did make a couple of payments to NEC, but there was more. I think it was $546,000 that was deposited in the accounts in the 3 months leading, actually 4 months if you count October, leading up into and right after the filing of the complaint. And Mr. Gary claims in an uncorroborated, unverified, and unsupported affidavit that he didn't have the money to hire a lawyer because my client had said bad things about him sometime in the summer of 2025. He claims he didn't have the money in October of 2025 when the complaint was filed, but the bank statements show otherwise. I mean, I don't know what he did with this $546,000, but the allegation, unsupported and uncorroborated, that he didn't have money because of something that my client did is completely unfounded, Your Honor. So Mr. Gary had more than enough money to hire a lawyer in October of 2025. This is not a case, the usual cases for excusable neglect are I miscalendared the date. Something happened that caused me to miss court. Something like that happened. That's not what we have here. What we have is a untrue and unsupported affidavit filed by the defendants. If Mr. Gary didn't have money to hire a lawyer, he could have contacted the court and said, I see it happen all the time. When motions for default judgment are heard, people stand up and say, Your Honor, I can't get a lawyer because I don't have money, or I'm trying to hire a lawyer and I can't get one. And a lot of times the court will say, okay, and they'll reschedule the motion. Mr. Gary did nothing. He chose not to respond to the motion for default or to defend the case in any way. And so under those circumstances, we don't have the type of excusable neglect that supports a Rule 60 motion in the rare instances that Rule 60 motions were granted. Mr. Kraft has not cited, and I couldn't find, because I don't think there is one, any case that says that I didn't have money to hire a lawyer means that you should undo the default judgment that was entered against me months ago when I did nothing to try to delay the proceedings or anything like that. Because if I didn't have money to hire a lawyer was enough to get judgments undone, then there would be no final judgments in the state of Tennessee. Everybody could just come in months later and say, well, I didn't have money to hire a lawyer, so please undo the judgment. But there are no cases that support this because it's not supportable under Tennessee law. So even if Mr. Gary didn't have money, and frankly, even if he didn't have money because my client called him untrustworthy and incompetent, which he absolutely is, that is not the basis for a Rule 60 relief based on excusable neglect. Also, Your Honor, in order for a defendant to be entitled to Rule 60 release, they have to demonstrate that they have a meritorious defense. There's been no demonstration of any defense in this case. All we have are the unsupported statements, basically the unsupported denials of Mr. Gary. But the bank statements that are attached as exhibits to my response show that our claims are valid and he doesn't have defense because he was receiving all of this money, which just went out to places we don't know. And my client did not receive anywhere near what they were supposed to receive. So his just denial saying I didn't do it, it does not demonstrate a meritorious defense when it's not supported by anything else. So again, even if his assertions are true, it does not give rise to Rule 60 relief. And finally, Your Honor, the last reason why the court should deny the motion is that a Rule 60 motion has to be filed within a reasonable time. This lawsuit was filed last October. The default judgment wasn't entered until March. Mr. Gary states in his affidavit that he, in March, he started doing business again because he persuaded this company that what my client had supposedly said was wrong. But he still waited 5 months to file his motion, Your Honor. And under those circumstances, the plaintiff submits that that is not a reasonable time. So for all those reasons, the plaintiff respectfully requests the court to deny the motion unless the court has any questions. That's all I have.
All right. Thank you.
Your Honor, as the leading case is Sizemore, a Tennessee Supreme Court case, it lays out 4 factors. The danger of prejudice to the party opposing. Very hard to see any prejudice when there's interest that they've accrued. The fact to the answer and affidavit he has submitted, he has sworn to the facts that they are true. He has submitted an affidavit in connection with Rule 6002 motion. The time deadline is 1 year, except for except for 5. But this is within 4 months of the default judgment, not a judgment on the merits. Excusable neglect is an equitable doctrine, and the potential impact very small. He explained why it was late, and when he had control. Now, his response was filed on Saturday, and as I told the court, I didn't have a chance to look at it until late yesterday, and I hadn't been able to get a hold of my client. But I think I need time to respond. He's filed in good faith. He has asserted meritorious defenses and a counterclaim, which are sworn to. And when you file an answer or a complaint, it's a verified counterclaim. It is sworn to, Your Honor. There's an affidavit that's attached to it. Now, the affidavit talks about what happened, and it's sufficient for Rule 62. This is not a proceeding in the trial where we put on proof of witnesses. There are affidavits in the record, affidavits which support my client. And trying a lawsuit is not considered prejudicial to a plaintiff. That's the Urey case, which is a Supreme Court decision of last year, Tennessee Supreme Court. Fact of the matter is, my client is asserting that he's owed money. My client's asserting that he's owed commissions on other sales, and that the boat that his own was taken by them. So, Your Honor, this is not, and that he's saying that a lot of what the plaintiff is contending is simply not true. Equitable, what this means, excusable neglect. If someone has unclean hands, and we assert they do, we have affidavits to that effect, and we're ready to go with this case. We're ready to file an answer and a counterclaim today. The attached to the motion were the motion for the order for default, and the affidavit, and the proposed answer and counterclaim. So I urge this court to grant the Rule 6002 motion, or at least give me a chance to respond to Mr. Oakley's filing on Saturday. And as I said when I spoke, I filed it on Tuesday. I'm not claiming he was dilatory whatsoever, but I'm claiming he's made some serious allegations I'd like a chance to respond to. Thank you.
Well, considering the fact that the motion itself was filed less than the 5 days notice given to Mr. Oakley, and his response obviously was under the pressure to get it done before this hearing today, I am inclined to grant the defendant an opportunity to respond to, because there are some pretty serious allegations that Mr. Oakley makes, and that is that Mr. Gary's affidavit is false and contains false and easily provable false allegations, and bank records which tend to indicate that the defendant or that the plaintiff is correct. And that's, I mean, I've made a cursory review of them, and it does appear that if in fact Mr. Gary had $500,000 come through his business in a period of time, that he certainly could have afforded to hire an attorney. But beyond that, I don't know that, as Mr. Oakley states, that it's a basis for a Rule 60 excusable neglect, that in fact he didn't hire a lawyer because he claimed he didn't have the money. That's not necessarily in our jurisdiction a basis for that. So what I'm inclined to do is to withhold a reserve ruling on the Rule 60 motion, and I'm going to go ahead and enter an order that, because of the fact that it's being reserved and we're still going to argue it, to order that the charging order be put down, so that any funds that you need to protect yourself with could put a charging order down, that would follow this judgment, would follow those funds until we can have that Rule 60 motion. That is the best I can determine is the fairest way to give both sides an opportunity to present fully. But I do think that it's a higher burden than simply saying it's not fair, that he didn't have the opportunity to hire an attorney, and that, look at his affidavit, he says that they're wrong and he's right. That seems to me not to be sufficient, but I'm going to give you an opportunity to respond, and I think we need to have a hearing on it. The question is how quickly we can get that heard. Are either of you opposed to traveling outside of this county to have a hearing?
I'm not, Your Honor.
I'm not, Your Honor. I just need to check my calendar. As far as the charging order is concerned, all money would have to remain in place and couldn't be spent without court approval. Would that be correct?
All money what?
All money in the charging order
We can put in the charging order that the money will be paid into court.
Correct.
or into an escrow. It doesn't.
Or escrow. We'll work that out.
But as long as it's
Two of you can agree on something that would be satisfactory to me. So,
okay.
How much time do you need to respond? Because I want to give Mr. Oakley an opportunity to review what you file as well.
Your Honor, if I can get to my calendar, I'm not real fast at this. I apologize. 73, and I don't do this for if I could have a couple of weeks, Your Honor, that would be grand. I think unless that's the 4th of July weekend, I don't pressure on either of us. Whatever you want.
We're way past the 4th of July.
You're right. I'm
That
sorry.
was August.
Sorry, I look in July. Old age.
How long? Well, you were going to have 30 minutes this go round, but
Yeah. How about 3 weeks? In 3 weeks, that puts us right after Labor Day. Is that okay?
right after Labor Day. That's more than
for,
3
for-
weeks.
Yeah, for me, 3 weeks, and then Mr. Oakley, 3 weeks. That sound reasonable?
I don't need 3 weeks, Your Honor. I mean, I need a week. So I think a month from today, whatever's closest
Do
to
what?
that, whatever's close in the area of approximately a month from today.
Well, here's how my schedule works. I'm going to be starting the rest of this month. I have Chancery tomorrow. I'm sorry, I have VOP day here tomorrow. Then I have Dickson Chancery on the 29th. I have Humphreys County Chancery in Charlotte by 2 lawyers who agreed to move theirs to Dickson County. On the 30th, I have Dickson criminal motions on the 31st. Then I start Stewart County on the 3rd of August.
You know where you're going to be in October, Your Honor?
Do what?
What county will you be in October? I mean, in September, rather. Excuse me.
September, I'm in Dickson County.
How about that?
I'm sorry, Your Honor. I don't know if I understood from what you said. If there's something available sooner than September for Your Honor.
Well, that's what I'm looking at. So
Stewart County.
all right. What about the 17th of August?
It works for me, Your Honor.
1 second, Your Honor. If I can get to it, I'd appreciate it. 17th of August. I have a telephone hearing in the morning. That should be done by 10:30 if we can do it in the afternoon.
Well, I'm supposed to have a circuit civil docket call in Chancery in Houston County, but those dockets are usually very light. So I'm looking at probably 1:30 in Charlotte, Tennessee. I need to step off and call the clerk to find out if that's doable. So give me a minute.
Yeah, register.
All right.
They register. Yeah. You know. You have to go up to Clark's. I saw. I go that.
guardian ad litem, is it okay if I take a table?
All right, this is a motion. What I'm considering today is a motion regarding the enrollment of the children, minor children in Cheatham County schools. That request that's been made.
Yes, Your Honor, that was my motion. That was,
You want to wait till your client can come in?
if we could.
And Your Honor, I also, thank you. I also filed an answer or a counter
Just
motion.
come to the podium.
Thank you.
I don't know why that microphone doesn't seem to be working.
I filed a counter motion this morning. I've emailed it to both of the attorneys, and I set one up there with Miss Pam. I am asking that instead of allowing father's motion to enroll the children in Cheatham County, that the children be allowed to come up to Indiana and enroll in Eastern DeKalb County in Indiana.
Okay, I'll hear both sides. The first motion that was filed is that of the father who is asking to enroll the children here in Cheatham County. So we'll take that up first, and then I'll let you present whatever you want on your motion.
Thank you, Your Honor.
If you'll just have a seat. We're waiting on Mr. Brown to come into the meeting.
I could call him too if that might speed it up. It's saying incorrect password.
On this, what I gave you, that surprised me today. If it's a phone call, it may be somewhat different. Do you have the information? Can you give it? There's a different password, I
Phone
think.
call or the app?
If he's coming in on Zoom on a computer, you should be able to.
Here, let me send you a different picture.
Is your client still trying to join?
Yes. I told him to also try the phone option if the video is not working, the call in. And I double checked the number on the sticky is the same one on the email printout. Is it still not letting you? Oh, okay. Well, all right. Hang up and I'll just keep trying.
I have admitted apparently you're a client. So if he wants to be a participant, he can turn on his camera. If he's coming in on the phone.
I am in your honor.
Right. Then we are ready to proceed on your motion.
Yes. Yes. Your Honor, this is my client's motion. This was originally filed early in June. I believe it was sent in on June 5th, in fact, before any hearings were ever set on this case. My client wasn't served with a petition when the mother left the children with him and went to Indiana. For all he knew, she was leaving the children with him. He had no understanding what her plan was to file a petition. Then it took a while to get him served. He's been concerned about getting the children enrolled in school. Last year, they were in kindergarten in 5th grade in Clarksville. Neither party lives in Clarksville, even though this court has already denied mother's emergency request to relocate the children to Indiana. The mother's still residing in Indiana. The children need to be enrolled in school somewhere. My client's position is that allowing the mother to have the final decision if they're unable to make an joint educational decision that the current parenting plan allows for will put him in a position of the mother going ahead and enrolling the children in school in Indiana. He also has concerns about the elementary school in Indiana, which is rated pretty low as in comparison to the Kingston Springs Elementary School, which it looks like it is a 10 out of 10 from his research. He wants to keep this case moving forward, but we're kind of up against the clock on getting the kids enrolled in school pretty quickly. He's willing, he's able to get the kids to and from school, and still make reasonable accommodations for the mother to be involved to the extent she can, even though she already had moved to Indiana. As far as opening, that's all I have. If you want to let Mr. Brown, did you need him to turn his camera on? I do notice that that's not on.
Mr. Brown, you'll need to turn your camera on, please.
I don't know if it'll allow because I'm on the phone call side of it. I don't see any option for it. Just my normal keypad for a phone call.
Okay.
Since the Zoom app wouldn't allow me to log in.
Then let me hear from Ms. Selena. Well, Ms. Squires, you want to make an opening statement. I understand your position. You pretty much have given me your opening statement a moment ago. Do you have anything else to add? I'm going to give you a chance to testify if you want to testify.
I would like to testify.
Ms. Salinas?
Your Honor, I have been on this case about 2 weeks. I do have some concerns. I've been able to speak with the mother. I've been able to speak with the father, and I've spoken very briefly to the children via Zoom. I realized the children attended school in Clarksville, and it looks like they maybe attended, the oldest child may have attended there a little over a year. And then I think she had attended in West Cheatham at some point in time. I don't believe she's ever attended school in Kingston Springs. And I will tell you, I have two girls who both went to Kingston Springs, and it is a good school. But a concern to me is I met with Father in my office just a few days after I was appointed, and I had asked him some questions, and I had asked him to send me some photographs of his home, just so I could have a better idea of where the children would be living. And as of today, I had not received, well, as of today, I've not received photographs from him. So I drove out there yesterday, and I have some real concerns about the environment that the children would be staying in if they were to reside full time with the father. He was very honest and forthright with me in my office. He had told me that he had, and I don't remember how we came on the subject. I guess I was maybe asking about where the kids would be able to, to play and that type of thing. And he was very forthright and said he had only cut the grass a couple of times this summer. And I'd mentioned that, wow, we've had a lot of rain. It's been hot. Maybe that was something that needed to be done. And clearly, when I arrived yesterday, the grass is terrible. I don't know that there's any cutting it. I think it'd have to be bush hogged. There were several vehicles. It's just the house was not a conducive environment, at least outside, for these girls to play in, to bring friends over. And so that concerns me. I also asked the father if he smoked, and he said he did. And I asked him if he smoked inside, and he said he did. And so we talked about that. That concerns me. I also find the dad's lack of involvement with school concerning. So I have some concerns, and I'm not certain that the children being enrolled in Kingston Springs would necessarily be in their best interest. So what's the other alternative? They can't go to school in Montgomery County. Mom's not living there. And wherever they go to school, it might be temporary, whether it's in Indiana or in Cheatham County. But my position would be that Indiana, even if it's on a temporary basis, if that's what it ended up being, might be the better option. Mom has provided me with the information I requested. She provided it promptly, and I would submit that it's likely, at least in my opinion, a better environment for these children.
Go ahead. Ms. Knight, do you want to put on any proof other than argument?
I do want Mr. Brown to testify.
All right, Mr. Brown, if you can hear me, I'm going to ask you to let me place you under oath. Do you solemnly swear or affirm the testimony you're about to give in this case to be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, Ms. Knight.
All right. Mr. Brown, you heard some statements that the guardian ad litem mentioned to you about some concerns.
Yes.
Are you currently out of the state?
Yes, I am.
And how long have you been out of the state?
Since the day that I met with the guardian ad litem.
Okay. So have you been at home and able to take any photographs of your home?
No, I have not.
Okay. Now, there was some concerns mentioned about the condition of the grass. Is your grass pretty high right now?
Yes, it is. It's about 3 foot high, probably.
Okay. Can you tell me why your grass is that high?
Every time I mow, I get about partially cut through, and my mower deck belt breaks, and it's about $100 to $150 belt. I'm going to be replacing that mower.
Okay. So are the children able to play outside in the grass in the condition it is at your home currently?
Part of the front yard, but you'd have to walk a little bit through the front grass if you didn't go out the front door.
As an alternative to playing in your yard, where do you allow the children to play?
We go down to Burns Park quite a bit, splash pad and flight kites and playground at Burns. Also, other friends' house down there in downtown Kingston Springs. Go to their house and they play with the 2 other girls. some friends of mine on their trampoline in their backyard and all.
Is that something you do on a regular occurrence?
Quite regularly, especially the park. And the splash pad in Dickson and all that.
As far as your previous involvement in the children's education, how far away from your house were the kids in school last year?
60 miles from my place.
How long did it take you to drive from your house to their school?
Just over an hour each way.
If the kids had an appointment during the middle of the school day in Clarksville, would you be able to attend those during the middle of the school day last year?
Not really. It's an hour there, an hour back. I can't just sit around Clarksville all day. I try to work in appointments. It's a couple hours.
That you were not willing to participate, or that you were not able to participate because of your employment?
Employment and cost, because it's basically $50 a day running them back and forth to school to Clarksville.
Okay. Have you done any research into where the children would be enrolled in school if they were enrolled based on your residence?
Yes. Yeah.
Okay. And where would that be?
The school where the mother's at, the elementary school actually covers up to 6th grade, so both girls would be in that elementary school and not the junior high school. And their school ranking is a 4 out of 10. They're very low on the Indiana State. They're about, I think, 487 out of 500, just over 500 schools.
Okay. And have you done any research on the schools where the children would attend if they were living with you?
Yes. Okay. Kingston Springs Elementary and Harpeth Middle School.
Okay. And are those schools similarly rated to the school mother would be zoned for in Indiana?
The middle school, Harpeth Middle School, is currently, this last year, they actually ranked a little lower than their normal average. I believe they were a 6 out of 10, but Kingston Springs Elementary is a 10 out of 10. One of the top schools in Tennessee for elementary on the public side.
Did you do any educational exercises with your children during the school year last year when they were with you?
Just a little bit with Clara, not with Allison. She does great. She doesn't even never had homework anyway. So it was never any homework.
Okay. And during the school year, you were seeing them, was that Thursday night through Sunday night every other week?
Yep.
Okay. So your parenting time during the school year was somewhat limited, correct?
That is correct.
Okay. And now tell me about picking the children up on Thursdays and on Fridays during your alternating weeks. Did you pick them up early from school?
On Fridays, a lot of the time I would pick them up a half an hour early because they just have recess at the end of the day. And I'd pick them up there. They stop for early cutoff at 3:15, and I tried to get in there right between 3 and 3:15, and they release at 3:45.
Were you still taking the children to do physical activities since they were missing recess?
Yep. And that helped us avoid all the traffic of getting out, rush hour traffic and all sorts. So it doesn't take more than the hour and 5 minutes to get back.
Okay. If the children are going to school in Cheatham County this year, would you be able to get them to and from school every day?
Yep. And there's also a school bus already in the neighborhood. There's multiple kids up and down the street, girl next door, boy 3 houses down.
Are they similar ages to your children?
Yep.
Okay. Would you be able to assist the children with any homework or educational needs during the school year if they were enrolled in Cheatham County?
Yes.
Okay. would you be able to, if the children were enrolled in school in Indiana this year, would that impact your ability to be involved in their day-to-day educational or extracurricular lives?
Absolutely. About
And how
7
far
hours
away
away.
is that again?
About 7 hour drive.
And do you think that's an issue that the court should decide at an ultimate final hearing rather than at this juncture of the case?
Yes.
That is all of my questions for this witness.
Ms. Squires, you are representing yourself. You have the right to come to the podium and ask questions. I know you've been through this before representing yourself, but make sure that your questions are in question form.
Thank you, Your Honor. All right, Mr. Brown, I'd like to start first with your home. Is there any damage to your roof?
There is some hail damage on the roof.
And when did that occur?
The first hail damage occurred back in 2020.
Okay. Has your house ever been hit by a tornado?
The house was not directly hit by a tornado.
Have you received any roof damage because of a tornado?
Yeah, that's the hail damage and some wind damage from December of 2020.
Has that caused any leaking into your home?
I have leaking in my bedroom.
Anywhere else?
Living room has one little spot on the exterior wall that I've removed the drywall on.
Is that the area by the light switch with the plywood?
Yeah.
Okay.
There's a light switch there.
Is there a way that
There's no plywood.
Is there a way that I can show him this photo to see if he recognizes it? I know over camera.
I don't know if he's able. Are you able to see this
Oh.
proceeding, or are you simply watching or talking?
No, sir. I'm directly on the phone.
So he can't see it. I don't think there's any way we can demonstrate it to him. So.
Okay. I might be able to. We might be able to do this. On the opposite corner of the door where you have the plywood, on the other side where you had the love seat, up in that corner, is there any mold? Or has there been any mold in that area?
There had been.
Okay.
That was the major spot where I had to go up and patch the roof to get the leak to stop.
Okay. And when did you perform those repairs?
I repaired the roof and that was 2021, I believe, when I had to go up and put more shingles up there.
Okay. And with that molding, did you ever have an inspection done to verify that there's nothing dangerous growing in the home?
No.
Okay.
Never been sick.
Okay. And going again with your home, you said that there's a limited area that the girls can play in outside. Have the girls ever gotten into a tick nest?
Yeah, in the neighbor's yard.
Oh, it was in the neighbor's yard?
They got into a seat tick, baby tick nest, playing on the rope swing at the neighbor's yard.
So that wasn't along the property line?
No, ma'am.
Okay. All right, I'd like to go on to, have you ever left the children alone together?
I have Elshon at the house. The only time I'd briefly leave them alone would be to run around and get Gatorades and cigarettes at the market. Be gone for 5 minutes.
Okay, so you do leave the home, and do you tell Allison that she's in charge of Clara? Or how do you...
I say lock Clara up, but you can get a hold of Elle because he's in his room if they need anything.
Okay, and Elle is always there. You've never left the children home alone?
He's pretty much always there. I never leave him home alone for any long period of time.
Okay, so yes, you do leave the children home. You just don't leave them home for very long periods of time.
Brief periods.
Brief periods, but yes, you do leave them alone. And then, have the girls ever had any issues with that? Any kind of arguments, fighting back and forth?
Not the minute I'm aware of.
Okay. And you leave, you say Ella's in the back room to watch them. So,
yep. I'm going to notify him that I'm leaving.
Okay. So he's not out in the rest of the household. He just stays back in his room most of the time.
Yeah, he'll crack his doors.
Okay. And how's his health?
Fine.
Has he had any, has he been out of the home for any length of time because of hospitalizations?
Yep. In the past.
And what medical condition does he have?
If I should be testifying on somebody else's medical conditions.
Okay, I'll move on. Let's go ahead and go into education, and I guess some of their medical information is going to overlap into this as well. You're aware that I enrolled Clara Brown into Mark Their Words.
Objection, Your Honor. If she's cross-examining my client at this point, I didn't ask anything about any medical issues for the children. And if the court wants to clarify that she's free to go ahead and testify at this point and call him as her own witness, just it's going beyond cross-examination at this point.
How is it going beyond cross-examination? She's asking him if he's aware of her having enrolled the children in something.
In therapy.
She's asking about therapies and medical issues. That's not something that was brought up at all on his direct.
Judge Cross is wide open.
There is no limitation on, unless we're limiting the proof on a specific issue. But in this case, the therapy or care for the children, medical care or therapy for the children is in fact a factor that the court would have to consider if I am making an informed decision regarding the best interests of the children, enrolling them here in Cheatham or there in Indiana. So overrule the objection. Mr. Brown, if you will restate your question, Mr. Squires.
Thank you. Mr. Brown, are you aware I had the Clara Brown enrolled in Mark Their Words therapy for speech therapy services?
Yes.
And what is your understanding of that treatment that Clara Brown was receiving from that facility?
Pronunciation.
Pronunciation, are you aware of any diagnosis that they have given her?
That she needs, the paperwork that I've seen is that she was needing to work on different pronunciations of different letters.
Okay. Does phonological disorder ring a bell?
Not off the top of my head.
Okay. So you're aware that she's receiving treatment for speech, but you're not aware of the specific condition that she has been diagnosed with. Is that correct?
That's correct.
Okay. Do you recall ever receiving any communication from me trying to encourage you to participate in that therapy?
I know you were trying to schedule, because they wanted it 3 times a week, and you were trying to schedule it on Fridays also.
And when I wanted to schedule those on the Fridays in which you would be exercising your parenting time, what was your response to me?
I know you asked about taking her, and I had no objection to you picking her up and taking her, because you did offer that.
Did you ever clarify to me that you were okay? So let's make sure that this is clear. I believe you were referring to, during one of my attempts to get you to participate in this treatment, I offered to come out to Kingston Springs and pick Clara up and drive her if that's what needed to happen.
You are now testifying, and you cannot testify. You can only ask questions at this point.
All right, I apologize. Did you feel that there was a need for your daughter to have these services?
Yes, because she was enrolled late into pre-K and kindergarten.
Do you think it was helpful for her to be withheld and receive these services first before she started school?
She didn't receive them first. She should have been in pre-K at least 2 years ago.
All right, so this is, do our children receive any other therapy services?
Allison goes for anxiety. That's all I've been told.
That's all you've been told? Okay.
Yep.
Is Clara also receiving therapy services for an ADHD diagnosis?
I haven't seen any actual confirmation of ADHD diagnosis.
Have you scheduled an appointment for Clara with the psychiatrist that treats her for ADHD?
I have never talked to a counselor or supposed psychiatrist that's seeing her.
You've never spoken with Molly Fields?
That's the one that does it. She speaks to both of the girls.
Yes. So you scheduled
And she's
therapy services for your
she's
daughter,
never
but
given me diagnosis.
I apologize. Could you repeat that?
She's never given me a diagnosis.
Have you
of
ever asked
ADHD.
for it?
No,
Because you
that's
have a right
my
to your children's medical
understanding.
files. Have you ever asked for it?
One at a time, please. Let her finish your question, but let him answer the question you've asked.
Yes, sir.
You were having what they call a compound question. Restate your question. And I would point out to you again, I have one issue before me today. This is not a hearing on your permanent relocation request. This is a hearing on where the children should be enrolled for school until there can be a hearing on the request to relocate.
Yes, sir.
So limit your proof to those issues, to that one issue.
Did you schedule an appointment with Molly Fields for Clara Brown?
I scheduled the Zoom calls over spring break and Christmas break for both girls with Molly.
Okay. When do the girls usually receive their appointments with Molly?
I thought it was during school.
Okay. So outside of the school time is when we schedule appointments by Zoom with her? Is that your understanding?
During the breaks, I set up Zoom calls with her because she reached out to me requesting them.
Okay. All right. I believe we'll do you recall ever receiving any letters that Molly Fields has typed up in regards to the girls' diagnosis and treatments?
I've never received anything directly from Molly.
Hold on, Mr. Brown.
My client's already
Sorry,
stated
Ron.
it's not received
Mr.
any
Brown, wait just a
documentation.
second. Sustained, again, I want to focus the relevance of all your questions on the schooling and the education rather than medical care.
Okay, I apologize, Your Honor. The reason why I was pursuing this line of questioning is because by answering this, am I testifying? Okay, I'll stop. I'm gonna
You can give me your reason why you feel like it's relevant, but it's not going to change what I've just said.
Yes, sir.
What I want to hear is why you think the children should be enrolled in school in Indiana versus here, and any questions regarding the education that is offered that Mr. Brown can offer is fair game. But the questions about therapy, I've allowed some of that because it is a part of the care for the children as well. But if you can ask him any questions you want to about his proposal regarding the educational needs of the children, then that's what I'll need to hear.
Okay, I'd like to move on to the attendance records of the children then.
All right.
Ms. Knight, have you got a copy of that?
No.
Okay.
You provided it to me?
I wasn't sure if this was something that I had provided or not.
I've not received anything from you.
This is a temporary hearing and the discovery is not being completed. You haven't been to mediation. That's why this is a temporary hearing. So if you have a question for Mr. Brown about the attendance records for the children, go ahead.
Sure. Mr. Brown, what time does Barksdale Elementary end? Their school day?
3:45.
3:45. And how many days would you say that you pick them up early?
Most of the school year, I picked them up early, around 3 o'clock.
Around 3 o'clock. And you say this is in order to avoid traffic?
Part of it, yep.
Okay. Do you think any other parents in the school have to deal with traffic?
I doubt any of the other parents drive an hour.
Well, that's not what I asked, Mr. Brown. Do you think any other parents have to deal with traffic?
I'm going to object on behalf of the court. I'm going to object to that question as being requiring Mr. Brown to speculate about what other parents have to do or not to do. You have made the point about the fact that he picked them up 45 minutes before the end of school, which this court finds to be unacceptable.
Okay, thank you, Your Honor.
Any other questions?
No, Your Honor, I believe that will.
Ms. Salinas, you want to ask Mr. Brown some questions?
A few, Your Honor. Mr. Brown, you met with me for the first time on July 17th. Is that right?
Yes, ma'am.
And do you remember what day that was? I believe it was a Friday. Is that right?
Yep. Yes, ma'am. It was Friday. You got on hold of me on Wednesday the 15th. Yes.
Yes, and you very promptly replied, and I appreciate that. Now, when did you go to Indiana? So that was the 17th.
Friday. I got in late Friday night.
So did you go the same day that you had met with me?
Yes, ma'am.
All right. But when we met, you had disclosed to me that your yard had only been cut a couple of times during the summer and that it was pretty long on the 17th. Is that right?
Yep.
So
That is
it's
correct.
not, okay. It's not that it grew between the 17th and today, which is 10 days. Is that right?
No, that is correct.
Okay. All right. And we had talked about, at least I had relayed that it might be important to get that grass cut. Is that true?
Yes, ma'am.
Now I have in my hand 3 pictures of your home. What is the address of your home?
1018 Dogwood Lane.
All right. And unfortunately, you're on your phone and I can't show you these pictures, but I'm going to ask to move them as an exhibit.
I mean, I've never personally seen the house. I'm not saying I don't take your word. I don't have any issue stipulating that the grass is very tall.
Well, Judge, I'd like for you to see how tall the grass is, and I can't help it. He's on my
Ms.
phone.
Salinas is entitled to introduce whatever proof she wishes. Mr. Brown is not here, but his lawyer is, and she can review the pictures.
I have no objection, Your Honor, either. I know how it looks.
And there were several vehicles in the grass and one on the drive. And one looks like maybe one has a cover on it. Is that right?
Yeah, my roommate has a few vehicles there that he's stolen 2 of them.
Okay. And you said that the grass has not been maintained because you need a $150 belt. Is that right?
I can't even get one complete mow out of a replacement belt, so I'm just going to be replacing the mower.
Well, but you told me you were on track to have a record year from a financial standpoint with your business. Is that right?
On sales, record year of sales, if everything works out, if all the jobs finish. because it's a new construction project. So.
And certainly in the Kingston Springs and Pegram and White Bluff area, there are several lawn services that could come cut your grass. Is that right?
That is correct.
And I mean, your children, they're young. They're 11 and 6, right?
Yep.
They like to play outside, don't they?
Yeah, they usually go over to the neighbors down the street.
Well, do you think they'd ever like to have friends from school come to their home and play?
Oh, yes.
And it would be pretty difficult to do that in the condition your home is in currently, wouldn't it?
That is correct.
And you've been involved in this case for how long? How long has this
Years.
case been back before the, well, recently, how long has this case been back before the court?
On this matter,
Yes, sir.
let's see, since June.
So 2 months essentially, and you know you're kind of under the microscope right now, asking for the girls to come live with you primarily and be enrolled in school. And that, I mean, the yard certainly wouldn't show it, would it? That you're willing to do what's needed to get this home in a fit condition for the children to live in.
Just waiting on my cash flow on accounts receivable, and then I'll have a mower.
Well, but you had the money to drive to Indiana and be in Indiana for the last 10 days. Is that right?
Actually, a friend gave me the money to do it because I'm in charge of build and tear down every year.
Tear down of what?
The music festival stage, charity stage.
Okay. You have a roommate. How old's your roommate?
He is 62.
How long has he lived with you?
About 4 years, maybe 5 years now.
Do the girls
5 years,
have their own?
probably.
Okay. And I don't mean to talk over you. Do the girls have their own room at your home?
Yes, they have their own room.
They, okay. How many bedrooms does this house have?
3 bedroom, 2 bath.
Okay. So do the girls share a room?
Yes, they have bunk beds.
And how many baths?
2 bathrooms.
Let's just put
Move on.
a stop to it right here. Have a seat. This hearing today is designed for one purpose only, and that's for me to make a determination on a temporary basis whether the children should be enrolled in school in Indiana, where the mother is located, or has relocated, or here in Cheatham County. And the proof has been that they've never been, or at least have not recently been enrolled in Cheatham County. The problem the court has, and the hesitation that I've had, is that Miss Squires has moved out of the state and relocated to Indiana without having followed the procedure set forth in the law for a parental relocation. She instead filed an ex parte petition for relocation. And this court is very familiar with this case. I've heard multiple hearings in this matter. I've done my best to try to put an order down that would allow both parties to be a part of these children's lives. There have been a lot of allegations in the past that between these two. But nonetheless, Ms. Squires has been, under the prior orders of this court, designated as the primary residential parent for these children. She has had the children for a period of I believe it's 200 under the last order. She has the children for 222 days, 252 days a year, and he has 113 days per year. So the only question is, until we have an actual hearing on the relocation and whether or not she should be allowed to relocate or should be ordered to either return to the state of Tennessee with the children or give up custody of the children, which is what the final hearing will be about. The court has to make a determination where the best interests of the children lie, whether being left here with Mr. Brown and enrolled in a school they've never attended, or to Indiana in a school that they've never attended, and with the mother situation. Based on the testimony that has been offered at this point, I am finding that the motion to enroll the children in Indiana with the mother should be granted, and that the children should be enrolled in school there pending a final hearing on the petition for relocation. This order that I'm entering should be drawn by the guardian ad litem, in my opinion. Since Ms. Squires is pro se, I want to make sure it reflects everything the court is ruling. And this order is not to be determined by either party and shall not carry any significance regarding the final determination of whether or not a parental relocation and a relocation of the children to the state of Indiana is in their best interest. This is purely a decision that I make for the moment to allow, in other words, Ms. Squires had been worried about Mr. Brown wanting to have the children enrolled here so that he could have a snapshot of what it would be like for him to be there. The same thing could be said of Mr. Brown, worried about your having the children enrolled up there, and therefore you've got a record. I'm going to allow you to enroll them in Indiana, but the enrollment of those children in Indiana will not be a factor that the court will consider at the final hearing, so that both of you will have an equal opportunity to once again try to give the court an opportunity to make the decision that's in the best interest of the children. And hopefully by the next time we have a hearing, I'll be able to talk. All right, Mrs. Salinas will draw the order.
Your Honor, I am concerned as to what implications that might have on the current parenting plan.
Current parenting
once
plan
school
is in force.
From my client's parenting time is Thursday to Sunday night. That would be impossible living 8 hours away.
He's in Indiana right now.
He is coming back today.
Said, but I mean,
What school
he knows how
begins?
to get to Indiana. He went up there for a week-long music conference, apparently. So all I'm saying is that this decision that I'm making today was based on one thing only, and that is the question of whether the children should be enrolled. I have not altered the parenting plan. These parties need to come up with an opportunity through Ms. Salinas, if nothing else. Maybe they can use her as a medium to try to come up with a best interest for the minor children. He's entitled to have his visitation. And it just depends on how long. I'm going to order that they go to mediation as well, because I think that, well, mediation with Ms. Squires as a pro se would probably be counterproductive, I would think. So in any event, he will have visitation on weekends, and if it cannot make it work where he has the entire weekend, he will exercise as much of that, and that will not be held against him at the final hearing. Mr. Brown's situation in his home is a large part of the reason why this court has made it. I look at those pictures. I've had to mow my grass every week, even though I don't really want to. As soon as I get finished mowing it, I'm having, probably part of the reason I sound like this. As soon as I finish mowing it, I have to start all over again. And all I'm saying is that he's got minor children who need to be able to be outside in the home. Those photographs that I've been shown show almost waist-high grass, and that's unacceptable for minor children of this age. We got an 11-year-old and a 7-year-old. Leaving them alone for him to run out and get some cigarettes and Gatorade, that's highly questionable. Even though he's got a roommate in the back, it's not his roommate's 60-some-odd-year-old gentleman. Is not, in this court's opinion, it's not his responsibility to provide for the care of the children. So he has a house that's leaking, that's had mold in it. All of those things are factored into this court's decision. And the guardian ad litem's report about her concerns is also a great part of this. So while it is inconvenient that this has happened, Mr. Brown may have a remedy available to him at the final hearing for Ms. Squires as having unilaterally left the state of Tennessee without prior court approval. So we'll deal with that. So, all right, Ms. Salinas, you draw the order.
I will, Your Honor.
And that concludes our business for today. We stand adjourned.
All right, court's adjourned.
anticipate getting the next motion date for a temporary parenting plan? I'm not sure on that exercise Thursday at 7 p.m.
Well, he could go. I mean, there's got to be some options. There's got to be some middle ground. Maybe he gets an extra. Having her is maybe a little tattoos. Let's talk about it and see.
I know it doesn't start till later, so we have a little more time up there. But once they start, they can't drive down.
About an 8-hour drive home. Y'all have a nice one.
They can't. They have to drive back all day.
Butler, Indiana.
She said that it starts around the 13th. So initially, I thought they usually always start at the end of the month, but
I'm going to let you know that if you want to send over a proposal about some temporary parenting time once school starts. Otherwise, I do anticipate getting on the next motion docket.
and I'll maybe send you both what I think would be good for the kids. If you'd like to see that, I got to think about that. So, I'll send you both a copy of the order to look at to make sure. I mean, if you think there's something I missed, let me know. And then we can talk about it. It's pretty straightforward order. So, okay.
Can you double check the begin date and let us know?
Yeah,
It is for sure.
August 13th.
Okay.
Yeah.
I'm gonna go ahead and send you a link. I had created a Dropbox of some files that I had sent to Miss Lena, so I'm gonna go ahead and send that over to you, and that's got the school calendar in there as well. So that way you can look at it for your proposal to see what they can breaks.
I'm not making a proposal right now. I'm anticipating having to file a motion, but I do invite you to send him a proposal to me. I'll share it with him.
But you know, his last day is his last civil day here.
I know.
Until.
I know. That's the problem.
So it's been a problem I've been dealing with.
It's a problem.
Dates
Some
are
of it I have to go in front of a different judge. I hate to do that because
that's usually not how it works.
No, I'm just trying.